trying to pound a square peg into a round hole. But here we are. Ms. Hines, what's the status here today?
I talked to Mr. Musiak last week. He told me that he would forward to me a plan to have all the property removed. I even sent him an email at 10:19 on 11/14 to give him my email address. Have not heard from him. 19 on 11/14 to give him my email address. Have not heard from him. My client has not heard from him, and all his property and animals, cattle are still on my client's land. And we're asking for a judgment of possession.
Mr. Musiak, what's your plan?
The email was sent to Council Hines last night detailing my losses or what I'm looking for in compensation while renting the land. I don't know if you could check your email by phone. You may see it, but it did not come back to me as unreturned, so I'm assuming it was delivered. So it details what I'm looking for in compensation for losses, and I still intend to remove the cattle from the property. I did get pictures from Mr. Lugie of one picture of every animal, and I'll have to visit the property myself because he knows I need a profile from each side and a frontal in order for me to post these animals for sale. And if he cannot provide that level of detail, I'm happy to make the trip out. I am concerned that one of the pictures showed a calf in a condition that I would report to animal control in St. Joe County for neglect because of the state of let's call it the manure on the back end of the calf was something that put the calf's life at risk. So
you're going to report yourself to the animal control for not caring for your animals?
Yeah.
No, I'm not going to report myself. I'm going to report Mr. Lugie. He's still charged with the care of the animals based on his breakdown of what I owe him for costs. And Your Honor,
well, you want it both ways, but if you're going to sue him for money damages, you certainly can do that. But this is a possession judgment that you have to remove your stuff. So if you're concerned about the condition of your cows, I would suggest you come get them sooner rather than later. You have 10 days to remove them off the property. And we're going to have to finagle that perhaps a little bit because today is the 21st. That would take us to December 1st, which is a Monday, first day after the Thanksgiving holiday. Have you got a place to put them?
I will confirm that today. I had residences lined up for everybody, including some animals going to processing. And Your Honor, in lieu of the fact that all the cows now have calves and every move of a cow will take an individual trip, I'd like to ask to move the removal of them to the end of December.
No, we need them moved now. He's had plenty of time to get these moved.
Their answer to that is no. There may be a little bit of a grace period, but they served a notice to quit on you some time ago, back in May, and they're still there. So they're not willing to grant more than the 10 days.
My client has been in contact with animal control to come check the cattle, and we've been in contact with Bruce Morris and animal control if we need to do an eviction.
This is a very odd situation. This has to do with possession of the property. So if you believe he owes you compensation, you can file an action either in small claims court for up to $7,000 or general civil court if you believe it's more than that. But at this point, you got 10 days to remove the property, or they can take steps to remove it. There may need to be a little grace period if you can't get them all off of there in time. But by the letter of the law, you have until December 1st. He has 56 days from today to ask for the writ of eviction, but he doesn't wish to go all the way through the month of December. I guess he could if he wishes to, but the date for the removal is December 1. That's also the date for the appeal. Apparently, you sent an email overnight. I guess Ms. Hines, when she gets back to her office, can take a look at that and share it with her client. But this is not about money, it's about possession. So you got 10 days to get your stuff out of there. All right, good luck and good luck to all these cows, Mr. Miziak. I hope you can accomplish this before the December starts. Good luck to you, sir.
Thank you, sir.
All right, Ms. Hines, I'll give you a copy of that and you can take it out. Get what you need. All right, now I've got ready to start my regular old docket.
Thank you, guys.
Thank you. All right, Laura, you and Grace can listen to that song later today.
I will.
I know you
I
know
wrote
it.
it down.
I know you know it.
Normally I just type it in my computer. Congrats on the baby.
Thank
Could have
you.
waited one more week and then.
Yeah, that was, she didn't have any interest in waiting that long. Mr. Boyer, which case are you here on?
I just joined, I have my own at 9:40. Probably shouldn't be here, but I was just checking to make sure everything worked.
9:40.
Mr. Carolyn Wise.
Oh, yes. That's the Bentwaters. How are you connected to that one?
It's my mother.
Oh, is it really?
Was my mother, yeah. She's deceased now.
Yes, she passed away. All right, and I think that was a while ago, so you guys have been in there. Yeah, all right, you're in the right spot,
Oh, okay.
but you're early, so if you
Yeah.
want me to just put you in the waiting room, I can do that if you want to watch the other proceedings.
Yeah, that's fine.
Put you in the waiting room?
Yeah.
All right. I'll bring you in when we get close to that time. All right, I've got Judy R. Which case are you here on, Judy R?
The Andrew tomorrow,
You're here on behalf of Walnut Meadows?
correct.
Okay. All right, the next several cases are Mr. Thornton's. His are always very well organized, easy for me to deal with. Apparently, I may have at least one criminal arraignment to fit in here somewhere also. Yeah, we've got the next batch fairly close together. 9, 9, 10, 9, 15, 9, 20, 30, 40, 50, 10. So we'll see. I like it when people come in early, so I don't have to do the advice of rights over and over again. So we'll hope for the best here. They sat in on the morning session, so we had 5 guests. People from Ontario, very nice folks. They drove all the 6.5 hours to get here. I think everybody's greatly underwhelmed when they get here and see just me in this little brown room. They did say we needed a Tim Hortons around here, and I guess I'll agree with them. We may actually be related in some manner. I tried to discern whether we were, but I couldn't tell. My Middleton relatives all came from Ontario by way of Liverpool, England. So I'm not sure what's up with Mr. Thornton. He's usually there. He is. He's here as defendant. Good morning.
Good morning.
We've got several of your cases this morning. They're usually all well organized and easy to deal with. We're off to a slow start. It's 9:04. Leandro tomorrow is not here, and Judy from Walnut Meadows is. So let me call this first case, Walnut Meadows Apartments versus Leandro tomorrow, and any other occupants at apartment 307. Mr. Lance Thornton is here on behalf of the plaintiffs, and the manager is also present. This is filed as a demand for non-payment of rent. Here's Leandro. He's also late.
I think this was scheduled for 9:10, Your Honor.
Oh, yes, it is. Nobody's late. Yes, it's 9:10. We had a 9 that settled. Good morning, Mr. Tomorrow.
Good morning.
This is Judge Middleton. Your manager, Judy, is also here, and attorney Lance Thornton. I was hoping maybe I'd get some other customers here, but we'll go ahead and advise you of your rights. I better bring Mr. Boyer in. Might as well advise him too. Lance, I don't believe Meg Bauer is going to be with us today.
Okay.
Mr. Boyer's out doing other stuff. I'll put him back in the waiting room. Julie Daler has joined us. Which case are you here on?
I am here for Klein and Lopez.
All right, from Sturgis Place Apartments?
Correct.
All right, very good. All right, we have only one defendant here. We have 2 apartment managers, 1 defendant. And so, Mr. Tomorrow, let me advise you of your rights as a tenant in a landlord-tenant proceeding. You may have heard these before, but as a defendant in a landlord-tenant proceeding, including this one, which is called non-payment of rent, you have the following legal rights. You have the right to obtain counsel for representation in this matter If you cannot afford an attorney, a legal aid attorney may be available to assist you. They're normally here with us on the feed, but she's off, I think today and next week. We gave you that information, or you may seek other legal advice. You can also hire a lawyer. You have a right to a trial by a jury or by the court. If you do wish to have a jury trial, you must tell the court here at this first initial hearing or make the demand in writing within 5 days using the jury demand form, and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay it. You have a right to have the case heard here in St. Joseph County where the property is located. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that's what this situation is, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, that's Community Action Agency, Housing Assessment and Resource Agency, that's Neighborhoods, Inc. Or if you're a veteran, you may be eligible for some veterans assistance. We sent that information to you with the original summons packet. You may be able to reach an agreement with the landlord by going through mediation or community dispute resolution. If both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord. That means the case would get dismissed, in which case the court would assist you or counsel would prepare what is called a conditional order of dismissal. Mr. Tomorrow, in this case, Mr. Thornton has provided a very helpful breakdown of what they contend that you owe through the month of November. We've got October's rent, $745, November rent $800, November late fee $45, for a total of $1,590, plus water costs of $65, plus court costs of filing service and attorney fee. It adds up to $1,839. What's your response to that?
While I don't know the other numbers, what is owed for the apartment is true.
Say that again.
While I don't know the other numbers, like the court fees and all that, to be what I owe for the apartments is true.
Okay. Do you have a plan to try to catch up?
Yes, I've recently, including now, which is why I'm sick now, I've taken up overtime and all that to help pay this back. I do not disagree with them wanting to remove me. That's fine. That's just desserts, but I do want to pay them back, yes.
All right. So you said you're working at Metal Technologies?
No. I'm picking up overtime.
All right. Where do you work?
T-Mobile. I sell cell phones.
All right. Well, I hope you can sell a lot of them soon, because the law requires we adjourn this matter at least 7 days. And so next Friday is a court holiday. We're not open on the day after Thanksgiving. So that takes us to Monday, December 1st. And Lance, let's see how that works for you, because we're going to have to put several cases in there. How are you for 2/15 on Monday, December 1st?
That works, Your Honor.
Mr. Tomorrow, by the time we meet next, another month's rent is going to be due. December's rent will be due. So they claim that you owe $1,590. You might as well add $800 to that for December. So you're going to owe $2,639.33 without a late fee or any other water. So that's what you need to pay. If you don't pay that, you would be subject to being evicted 10 days later, which would be December 10th. So my suggestion is that you haven't paid full rent October or November, and I don't know that some overtime between now and the next 10 days is gonna pay any of this, but I would suggest you stay in contact with your manager. I don't know if you're eligible for any housing assistance. You may check into those matters as well. There's not a lot of business days between now and December 1st, really only 3. So stay in contact with your manager. We'll talk about this further a week from Monday, December 1st. So that'll be 10 days from now. Do you have any questions?
I did not.
All right, I'll see you then. Hopefully you get a big commission or something and get caught up on this. All right, I'll see you December 1st.
Thank you much.
Next is the Sturgis Place Apartments cases. They have a new manager, Julie Daler is here. Lance, I wish I could get everybody to file your judgment forms. I had some out of county counsel. They assigned a young guy to the case. The poor guy, it was just a lump sum and he couldn't, it was a mobile home park, and how much was lot rent, how much was trailer rent, and how much was water fees, and and the tenant's entitled to know what the deal is. Maria Matson has gone on to other things, and we have a new manager, Julie Daler. This next matter is set for 9:15, which is 1 minute from now. And here they are, somebody by telephone. Good morning. Someone's joined us by telephone only. Who am I speaking with?
This is Haley Klein.
All right. The other tenants are Amy Schmidt and Anna Schmidt. Is she there with you?
No, she is not.
Where's she?
I do believe she's at work, but she does not live here. And when I talked to the person who gave me my notice, they told me that I don't think it would fall back on her anyway then, since she hasn't ever lived here either. And I do take full responsibility for it.
Is she a co-signer?
She was, yeah.
All right. Well, Lance, I hope everyone doesn't show up every 5 minutes and we'll have to do this over and over again. But Ms. Klein, you have certain rights as a tenant in a landlord-tenant proceeding. Your landlord has asked me to pay the rent or move. This is some of the most expensive rent we have in St. Joseph County, at least apartment wise. We have some houses that are now renting for over $2,000, but your rent is $1,215. As a defendant in a demand for non-payment of rent case, you have certain legal rights. I want to tell you about those now. You have a right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. They're normally here with us, but they are not here today. But I did provide the number for you to contact legal aid. You have a right to have the matter heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. Almost all of these, in fact, every one in history has been a bench trial, but You do have a right to demand a jury trial. If you wish to have a jury trial, you must tell me today or file a written demand within 5 days and be prepared to pay the $50 jury demand fee, lest the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from residential property because you haven't paid rent, that is this circumstance. You may be able to get rental assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, that's Neighborhoods, Inc. Or if you're a veteran, you may be eligible for some veterans benefit programming. You should have received that information with the original packet that we sent to you. You do not need a judgment against you to get that assistance, despite what DHS might tell you. Copy of the summons of complaint is sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, we can help set that up. You may be able to reach an agreement with the landlord that means the case will get dismissed, in which case Mr. Thornton would prepare what's called a conditional order of dismissal. Here they contend that rent is due partially for September. We've got October late fee and November late fee, and October and November's rent totaling $3,467. I'll allow a $50 late fee, so you would owe $3,367.54 in rent, $188 in utilities and renter tax, and court costs of filing fee, service fee, and attorney fee of $241.60. So the current arrearage through November is $3,828.02. Is that correct, Mr. Thornton? You're on mute, Lance. I think you were on mute. Can you hear me now?
Yes, I can hear you. It would be reduced down to $3,728.02 with the reduction in the late fees.
Yes, thank you. Ms. Klein, somebody apparently had co-signed for you, and they're not presently involved. Do you have a plan to catch this up, or do you plan to move out?
I do have a plan to catch it up. I did just start a new job and I did pick up doubles, so therefore obviously I'll be making more money. And I do just plan on paying it as much as I can go. So, and I do plan on selling my car. That way I can also get a little more cash, and that will also go to the rent.
All right, that might help. Now, the law requires that I adjourn this matter at least 7 days. And so we're going to adjourn this until December 1st at 2:25. At
Okay.
2:20, 2:25.
225. Okay.
Now, I don't want you to come in by telephone next time. If you can't Zoom in, I want you to come here live and in person at the courthouse. So someone maybe can help you with Zoom, but I don't like doing these by telephone. I can't see you. Now, let's talk about a couple of other things. At that time, we're also going to owe December's rent. So you're going to add another $1,215 or $1,425.
Yeah, there was
What
an increase from October to November. Yeah.
So the rent went up, wow, $210. So you're going to owe $5,000 plus dollars. And they aren't going to take it at $100 a week as you pick up doubles on your shift. You have 10 days from December 1st to pay the rent or be subject to being evicted. So they can, if they wish to, but I don't think they're going to enter into some sort of a repayment agreement where you pay a little bit each month, because you're going to be more than $5,300 in arrears. Your rent is very expensive. 1,425, and each time it's late, there's an additional $50 late fee. Plus the renter's tax and utilities, you're paying over $1,500 a month for this apartment. So maybe you'll get a lot for your car. I don't know. Now, they can agree to some sort of repayment agreement if they wish to. But for this much money, I don't know that they're willing to do that. My advice would be that you stay in contact with the manager.
Uh-huh. Okay.
Now, let me tell you what will happen. When we reconvene on December 1st, I'm going to recalculate how much is due. I'm going to add in December's rent, which apparently went up $210 a month. So it's $1,425. So that's going to be over $5,000. And you would have 10 days from December 1st to pay it or be subject to being evicted. So that would give you until December 10th to either pay the rent or move out. Eviction is when the sheriff comes and puts your stuff out on the street. It's not a very fun process. They can agree to work with you to get caught up on this, but they don't have to. So the worst case scenario for you is that you owe, let's add that up, 3728.02 plus 1425. Let's just put another late fee in there. You would owe $5,203.02. That's a lot of money.
Yeah.
So if you don't think you can pay it, you should think about plan B, moving out. If you do move out, you need to turn in your keys and give your forwarding address in writing to the landlord within 4 days of your moving. Now, Anna Schmidt signed as a co-signer. She doesn't live there. That means if they sue you for back rent and money damages, she's also liable for that. So she may be on the hook for that if you're not able to catch it up. That's the risk of co-signing for somebody. So again, Ms. Klein, my advice would be you stay in contact with your manager, let her know what you intend to do. If you think you can catch it up, great, then you get to stay there. If you can't, then you should think about finding another place to go. And people tell me this every week. I would move if I had somewhere to move to. There's not enough housing, and there's certainly not enough affordable housing. But this complex has a waiting list. They have people who'll be waiting to rent your apartment, even at this high rate of rent. All right, do you have any questions?
No, not that I can think of.
Okay. All right, I'll see you on December 1st at 2:25, either by Zoom or live and in person.
Okay, perfect.
All right, perfect. Thank you.
Thank you so much.
Okay. You can tell she's a server. They say perfect. Ms. Klein, best of luck to you. Perfect. When they take your order. If they're really good or been around for a while, they'll call you Hun. All right, someone's joined us known as iPhone. Who am I speaking with? Is this Irene Lopez? That is the alleged Andrew Rognus. But let's see if we can identify. Purported. That is the purported Andrew Rognus. Let's see if we can identify who iPhone is. Someone has joined us on an iPhone. Who am I speaking with?
Kevin Gushwa.
All right, Mr. Gushwa, let me give you a name. Let me see if I can get Mr. Boyer in here.
Yeah,
Mr. Boyer, can you hear me?
I can hear you. Yeah.
All right, you got your U.S. Postal Service garb on. As long as you're here, I'd like you to listen to what I have to say. I'm going to advise you and the other tenants of their rights in a landlord-tenant proceeding.
Okay.
Mr. Gushwa and Mr. Boyer, you are here on a landlord-tenant matter, either a termination of tenancy or a demand for non-payment of rent. In which case, you have certain legal rights. You have the right to hire an attorney. If you cannot afford one, you can ask legal aid to assist you or seek other legal assistance. You have the right to have your case heard here in St. Joseph County, where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance, or be prepared to file the demand in writing within 5 days of today and pay the $50 jury demand fee. I think these are both termination of tenancy cases. Yes, so they aren't a case where you're going to get emergency financial assistance. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested in that, the court can help set it up. You may be able to reach an agreement with the landlord that means the case would get dismissed, in which case Mr. Thornton could prepare for us a conditional order of dismissal. We'll set aside Lopez for a minute, Ms. Daler, and we'll skip ahead to Mr. Thornton's next case, which is Green Valley Apartments versus Gushwa. Kevin Gushwa is here. Mr. Thornton is here. This is filed as a termination of tenancy case. It says here there is no lease and they want you to move. Is that correct, Mr. Thornton?
If we're on Mr. Gushwell's case, yes.
Yes. Mr. Gushwell, what's your position?
Yeah, I plan on moving out. I've got a house. It'll be ready for me, I believe. It's like the second week of December. I'll be out of here.
All right. Well, the law requires that I continue this matter. Well, here's by the second week of December. Would you say you'd be out by December 15th?
What day is that?
That's a Thursday.
I'd say by
Oh, wait a
that
minute,
week.
that's a Monday. December 15th is a Monday.
I'd say I should be in that week. I would be out. Yes.
Well, we can agree on a consent judgment right now where you agree to be out by that date, or we can simply continue the matter until December 1st, and at which time we'll discuss it further.
Can we give me to the Friday of that week? Because I get paid the middle of that week.
All right, so you would say you would vacate by December 19th?
Yes.
Mr. Thornton, what's your response to that?
Mr. Gushwa is 6 months behind in his rent, so we'd like to stick to the 15th.
Well, the actual date for the writ would be December 11th. So this would give him 11 more days, and alleviate you of the obligation of having to go through an eviction. But we can discuss it further. The date for the writ, Mr. Gushwa, would be 10 days after December 1st, which is our next court date. I was seeing if we could just agree to be out 10 days later, and then they wouldn't have to go through the eviction. But at this point, they're
We
not.
would agree to the 15th, Your Honor, giving through that next Monday, because, I mean, realistically, we wouldn't get the order of eviction issued and served by that time anyway, so.
You're right. So all right, so they'll agree to go to the 15th. And if that's agreeable, we can do a consent order right now. What's your response to that?
Well, I get paid that Wednesday of that week, and gas money and everything, and I've dumped all the money I have into my, the place I'm going to right now, and it'll be ready that week. I just know that on this, I believe the 17th is when I get paid, so I'd have gas and everything to get, everything moved and everything.
All right, as he said, they've been trying to get you to move for months, but it's close. So I don't know. Let's just continue this matter to December 1st, 2025 at 2:40. We'll see how you're doing at that point, financially, moving wise. If they get what they ask for, you would have until December 11th to move out or be subject to being evicted. We'll discuss it further, but you have an absolute right under the new Michigan court rule to have a 7-day adjournment. Next Friday is 7 days. We're not here that day. So the next available day is Monday, December 1st. And we'll take a shot at this at 2:40. I should have realized how busy this day was going to be because we missed next Monday and next Friday. But we'll cram it all in there. Monday, December 1st at 2:40. All right, Mr. Gushwa, I'll see you then. Again, if you can only come in by telephone, I want you to either be here live in person or come in by Zoom. I don't like doing it by telephone. I can't see you. I don't know who I'm actually speaking to.
Right. I tried to do the Zoom and I couldn't get it to work for me. I'm on actually Zoom itself to make this call, but I couldn't get the video to work.
Well, that's a year. Yeah. All right. Maybe practice between now and then.
Yes,
anyway,
sir.
I will see you next December 1st at 12:40.
12:40 or 2:40?
2:40. Excuse me. Yes. Thank you.
Yes,
I do
sir.
that a lot. Good thing people are.
Good morning, Your Honor. Samchit Hart, P69542 on behalf of plaintiff.
All right. Good morning.
Good morning.
All right. And what is plaintiff's claim in this case?
Your Honor, this is a termination of tenancy case where the lease is expired on September 1st, 2025. So we're just seeking to recover possession of it.
All right. And sir, what is your position on this?
My position is, in fact, opposing party been discriminatory, biased, mafia, Ku Klux Klan. I left that property on October the 16th. I called the opposing party and I asked them, could I pay? October is paid. I say, could I pay for November and December? She said, yeah. Great. I said, give me a couple of days. I'll make the payment. No problem. Then in an hour and a half, she said, you got 2 hours to pay it.
Okay, sir, are you going to get an attorney to represent you?
Well, no, I'm not going to get an attorney, but I've been out the property. They asked me to leave. I left. She said, you come up with the money or leave.
Okay, so
I'm not in the property. They can have
So, sir, all they're asking for is possession, but you're telling me that you're not in the property.
Exactly. I was told to leave in 2 hours and I left.
Okay, but that's not my question. My question is, you said you're no longer in the property. Is that right?
That's correct.
That is correct. So if they were to go in to the property, you don't have anything there or anything else, so they
That's
can
correct.
take possession of the property.
That's correct.
Okay, that's all that they're asking for.
All right.
So
Judge,
what I will do is I will indicate that the defendant is indicating that he's voluntarily surrendered the property. And then Ms. Hart, I'm gonna put it over to next week, let you guys check. And if not, then the matter can be dismissed, I guess.
Fantastic,
Or
Judge.
if you do get possession, matter can be dismissed. If you don't, then we'll have to set it for something else.
Thank you.
Well, I was told, I didn't volunteer. They told me to leave. So I was forced to leave. With no stove, no oven, I was forced.
Well, sir, if you feel somehow, sir, I'm just going to say this to you. I'm going to put this over. Actually, it's going to be 2 weeks because of Thanksgiving. I'm going to put this over. If you feel that there is some claim you wish to pursue, you're going to have to file the requisite pleadings, and then we will deal with it in 2 weeks. I will adjourn this matter to
That's okay, Your Honor.
December 5th, 2025 at what time?
I won't be available.
At 3 p.m. That is an in-person proceeding. So if you wish to continue with the matter,
I don't
you'll
wish
need to show up at that point in time. Thank
do
you.
not
Have a
wish
great
to-
weekend and happy holidays to you.
Yeah, okay.
Court does call the case. Venture Property of Michigan versus Melissa Martin.
Good morning, Judge.
Who's on this?
He's muted. It's Attorney Andrew Harris.
Good morning, Your Honor. Andrew Harris on behalf of the plaintiff.
Melissa
Oh.
Martin, the defendant.
Thank you. All right, this is a termination. What is the basis for the termination?
The lease expired September 30th, 2025.
All right. And Ms. Martin, what is your position on this?
The non-renewal of my lease is directly connected to a open civil rights investigation that I have ongoing right now. I am asking
Hold on.
Okay.
Hold on. I just want to make sure I'm understanding what you're telling me. You have a civil rights complaint or claim somewhere?
Yes, it's an active investigation right now
With whom?
with the Department of Civil Rights of Michigan.
Okay, Michigan Department of Civil Rights?
Yes.
Okay, and that involves your housing?
Yes, it's that complaint is directly related to why the non-renewal of my lease was given and why it's being investigated for discrimination and retaliation.
Okay. Counselor, do you know anything about that or?
I do. This issue, along with others related to the incident case, were litigated in circuit court a few months ago and all resolved in my client's favor. It's circuit court case number 25001264 CE. So if these claims are going to be raised in this case, and it sounds like they will be, I'd like an opportunity to address them if the court will allow. Before a trial, it will be subject to a motion for res judicata, and likely.
Well,
yeah.
Okay, so, okay, understanding that those claims have been, or the claims at least in circuit court were resolved.
Yes.
Are the circuit court, are you indicating, I guess, counsel, that resolved the Michigan Department of Civil Rights complaint?
No, I am asserting that the argument about the civil rights complaint affecting my client's right to possession have already been litigated and addressed to a final ruling, but not the civil rights case in and of itself.
Got it. I think. Okay. So here's what I'm going to ask the parties to send there. I guess whatever documents from the circuit court proceedings I would need to see, or to, can you give me that circuit court case number? We can kind of look that up.
Sure. It was before the Honorable Judge Timothy Connors, 25-001 264-CE.
Dash Z initials on that?
C as in cat, E as in elk.
CZ. All right, I got you.
Okay.
Okay. Ma'am, were you at all part of that circuit court matter?
Yes, I was the one that raised it, and I had tried to talk to a lawyer to get help with this eviction case that helped me with the last one, and he kind of explained what I'm allowed and not allowed to introduce into this eviction case. So I know what I'm allowed to say and not. And again, like, I understand the civil court was dismissed for those reasons, but the civil rights investigation is still ongoing and still directly related to my.
I understand what you're saying. So, what you're going to need to do, so I'll be able to look up the circuit court matter. The Michigan Department of Civil Rights complaint, ma'am, I'll need you to file with the court a copy of the complaint and any documents you think relevant to that this court would need to see regarding that.
Okay, I did turn in Exhibit A, and it did have some of the email from the investigator.
Yeah, I do see. I do see it. I did not see on that the complaint itself.
Okay, I didn't know, so I will definitely.
No, it's okay. I'm just saying.
Yeah.
That's what I didn't see. I didn't see the complaint because okay. I just didn't. So I'll need a copy of that. Okay.
Yeah, I wasn't sure what I was allowed to turn in because I know that I'm not allowed to bring up certain stuff from so I wasn't sure if I was allowed to show a complaint.
Okay, I'm not sure where you get that from. If you're not allowed, I'll tell you you're not allowed. I mean, I don't know what somebody's indicated to you nor why, but I don't need to get into that. I'm telling you that's what I need to see.
Okay.
Okay. I will, since we can look that up and out to see, we can probably find that case. I'll adjourn this out to December 5th, 2025 at 3 p.m. That is an in-person proceeding.
Okay.
So the parties will need to be present at the courthouse. And then we'll figure out where we go, if at all, from there.
Okay. Would the court like any submission of papers from the plaintiff in the interim?
Whatever you'd like to send that may clarify it, but you're indicating that there was a circuit court case that was resolved, giving us a number. We can find that in the pleadings ourselves.
Okay.
So I'm going to have my staff get that.
Okay.
But if there's anything else you'd like to send, counsel, that might either clarify or muddy the waters, and certainly submit it to me.
Yes, happy to do so, Your Honor. Thank you. And Ms. Martin, I just sent you a response to your settlement offer in the pleadings. Please respond if you don't mind.
Okay.
All right.
Thank you.
Thank you,
Judge.
folks.
Okay.
All right. Court does call the case of Lakestone Apartments versus Christina Brigham.
Good morning, Your Honor. Andrew Cates, P78292 for Lakestone Apartments.
And she here?
Yes, she is.
Ms. Brigham?
I'm here. Excuse me, I have a cold. I'm here.
All right, thank you. All right, what is plaintiff's claim in this case, including court costs?
Your Honor, the claim including court costs is $2,125.90.
$2,129 and how many cents?
93 cents. 93 cents.
Thank you. All right. And ma'am, how are you intending on getting that paid?
I've already been in communication with management at the complex, and we've already worked out a payment plan to get it finished, pay it off while I continue to pay rent by March. A monthly payment plan, I guess you could say.
So you're saying that the landlord has worked out some payment plan with you?
I am, yes. Sorry.
All right. And counsel, you don't know anything about that, right?
I was not made aware of any agreement between the defendant and the client, Your Honor. At this point, I would request that maybe a brief adjournment so we can get that.
Yeah, I'll adjourn this out to the next date. Ma'am, I'll adjourn this to December 5th, 2025 at 3 p.m. That is an in-person proceeding, so you'll need to appear at the courthouse. Okay?
Is Lakestone not here?
Yes, I am here. We do have a payment plan for her, and I did send that over to Steve Gann.
All right, so Mr. Gann has that. Maybe we can get all the paperwork finalized and then get it into the court, however we're going to do that. But for right now, the parties would need to appear on the 5th. All right, thank you.
Thank you, Your Honor.
And Lakestone versus Simone Smith.
Good morning, Your Honor. Andrew Cates, P78292 for Lakestone Apartments.
And Miss Smith? I think that's her. You're muted, Miss Smith.
Okay, I'm unmuted. Good morning.
Okay, good morning. All right, what is plaintiff's claim, including court costs in this matter?
Your Honor, it is $3,042.44.
3,000. Say that again. I'm sorry, counsel.
3,042.44.
32.44. All right, Miss Smith, how are you intending on getting that paid?
Well, I'm still trying to work out, the money that I can come up with. I've also reached out with DHS, and I'm waiting on them to respond. That was, I want to say Thursday of last week. So I know they should be getting back to me soon with some assistance.
Okay. So you
say for sure.
You filed a state emergency relief.
Yes, that's the name of it.
Have you reached out to Housing Access for Washtenaw County?
No, I just was listening at the numbers you were giving, Hawk and the other ones, but I will reach out to them.
Okay, I would suggest that you reach out to Hawk as soon as possible.
Okay.
I'm aware at least there's some funding, and there may be more funding coming in at the beginning of the month. So
I have a question. Do I have to wait until I get the response from the DHS, or I can?
No, ma'am.
Okay.
No, ma'am. You can go right ahead, apply for that, apply for anything else that you can apply for.
Okay.
Now, what you will have to do is in your packet that you received to come to court.
Yes.
There's a form called a rental assistance form.
Mm-hmm.
You'll need to fill that out and put your DHS tracking number in that document. Okay. And file that with the court by this upcoming Wednesday.
So just complete that and send it to the court.
Yes, ma'am. You'll need to complete that form, send it to the court, and it just has to be filed by this upcoming Wednesday, the day before Thanksgiving. Okay. Now, just so that you're also aware, how many people are in your household?
Myself and my daughter.
Okay, so you have two.
Yes.
So when you look at the amount of rent that you have that's owing, understand that DHS under that state emergency relief is only going to pay about $520 if they give you the maximum amount.
Yeah.
Okay.
Yes,
so just so that you know that, so that you're not thinking that it's going to be some large number that.
Yeah.
All right.
No. Thank you.
All right. So I will adjourn this out to December 5th, 2025 at 3 p.m. That's an in-person proceeding. So you'll need to come down to the courthouse. Okay.
Okay.
All right.
Thank you guys for your time. All right.
Oh,
thank you. Have a good
ma'am.
day. Bye-bye.
You have a good day and you have a great Thanksgiving, okay?
I'm going to. You too. Go Blue.
No, we don't. Did you? You did that?
I thought I could sneak that in there as I was hanging up.
What? Why'd you do that to me? You know what, ma'am, Miss Smith? I expected to see Mr. Gann here saying something to me, but he sent somebody else. I know it's because of the embarrassment of what state's been doing. That's why he's not here today. But you can say go blue, and I'm just going to say go Terps. We'll see what happens.
Have a great afternoon. Bye-bye.
Bye-bye. Council, make sure to share that with Mr. Gann, and you take care, all right?
Thank you, Your Honor.
Thank you. Court does call the case. They got this in here weird. Looks like Brian and Kelly Kuhn versus David Jesse and Hillary Jesse. Okay, whatever.
Good morning, Your Honor. Randy Barker on behalf of the plaintiffs, and I will not say go blue.
God bless you.
I tried to explain to my daughter many years ago, now that she's graduated from there, that maize and blue makes green, but I know I would also get grief for my Spartan blood. So.
You see, you're not helping yourself. You should have stopped. All right. Are the Jessies here? They have not checked in.
I did not see them check in.
All right, you paid for second service. If you'd raise your right hand, I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go.
Your Honor, this is a recovery of possession with money judgment for non-payment, and also the lease expires at the end of the month. Just to give you a quick update, as of last evening, I'm advised by my clients that the defendants have vacated the premises, so we would be simply asking for confirmation, I guess, of possession and a money judgment. Total requested of rent, other money due, and costs is $9,141.66 based on information provided by my client.
All right. And I cannot grant a money judgment. I don't have proper service for that, but I will grant a judgment. Pardon?
Sheriff completed service. I just don't know that it's made it into the court file.
Yeah, it was mailing and attachment, no personal service.
All right, then.
All right. So I'll grant a judgment for possession only. Redemption amount in the amount requested with a writ issue in 10 days.
Thank you very much.
All right. Thank you. Have a great weekend and a happy Thanksgiving.
You too, sir.
Then I have Six Trails versus Cayenne Nash.
Good morning, Judge.
Oh, he is here. I see him.
I'm here, Your Honor.
Okay. There he is. All right. And Mr. Katz, what is your client's claim in this case? Oh, you're muted, sir.
Sorry about that. $4,127.
Say that again for me.
$4,127.
You broke up with that first number.
Oh, Your Honor, I was having a hard time getting my muted. $4,120.
I get 4,127. All right. Thank you. And Ms. Nash, how are you? Good morning. And how are you intending on paying this?
Good morning. How are you, Judge Simpson?
I'm okay, I think.
So I am going to pay it, but I do want to be evicted. I'm just asking for about 7 to 10 days left in the apartment. Most of the apartment's cleared out. I am 33 weeks pregnant and I have gravida emesis. So it makes me like really sick.
Yeah.
So I just want to leave it all behind. And it's like 78% done. I just want to vacuum and clean up the walls before I leave. So I'm just asking for about 7 to 10 days.
Okay, so you're going to
Your Honor, I'm assuming we're adjourning for 2 weeks.
Yeah, I'm going to adjourn it out for 2 weeks, ma'am. And so that you understand, they're only asking for possession of the premises. So if you're out turning the keys, they're going to dismiss this case.
Yep, that's the whole plan. I just wanted that little buffer right there just because I have been so sick during this pregnancy.
All right. So what I will do is I'll adjourn this out to December 5th, 2025 at 3 p.m. That's an in-person proceeding, but if you're out, have turned in the keys, you're not going to have to try to get yourself down here. Okay. You got more important job to do. All right. And be
Thank you.
down here.
I have 8 weeks left and I'm so ready for it.
Yeah, all right. Well, you're still smiling, so that's a good thing, right?
Yeah, it's a boy. They say girls take away your youth and everything, so I'm glad I got a little bit of energy.
I am not going to say that out loud. I'm going to let you go with that. All right. So, is it your first one?
No, so I don't know if you remember me during COVID, but I had custody of my brother and my daughter.
Okay.
And my daughter, she'll be 13 years old when I have this one. So it's going to be a huge age gap.
God.
Yeah.
13. Wow.
Yeah.
Okay. All right. Well, if I don't see you, which I don't expect to, because you're going to be out of the apartment and everything, I wish you all of the best in terms of the birth of your child.
Thank you.
And I wish that you have a very happy Thanksgiving and a happy holiday season. All right.
Thank you so much. I hope you do too.
Thank you.
Have a good day.
All right. And was that
Your
it,
Honor,
Commissioner?
my other three were dismissed, Your Honor.
Yes, they are. Six Trails versus Jansen. Is anybody here? Six Trails versus McCullough and Six Trails versus Stewart. All of those matters are dismissed on plaintiff's motion without prejudice. All right. Thank you. Everyone take care. That's it. 10 o'clock. All right. We will be back at 10 o'clock to continue on. Court stands in recess.
Taking care of me. All right, well, let's go backpedal here for a minute. Sturgis Place Apartments versus Irene Lopez and Danilo Marquez Diaz.
Am I
Mr.
free to go,
Grishwell, you're
sir?
good to go. Yep, I'll remove you.
Thank you, sir. Have a good day.
Thank you. That one is set for 9:20. The defendants are not present. They were both personally served. Mr. Thornton, what's the status on that one?
Still pursuant to the judgment information sheet that I provided, they owe $1,121.17. Since there was personal service, we would be requesting that a judgment enter today.
There were personal service on each defendant. This one isn't too terribly behind. Maybe they can get this caught up. Ms. Daler, have you had any contact with them?
Not about this, no.
I got 3 pens here that all don't have any ink in them. All right, they were personally served, as Mr. Thornton indicated, and they're subject to default. And again, these very handy cost breakdowns. Rent through November is $840, $854.37. Court costs are $266.80. There's nothing additional in here, no utilities or pet fees or anything like that. So the total amount through November is $1,121.17. I used to add the next month, which would be December. But I'm not allowed to do that by a ruling of the circuit court. Rent is $1,160. So as of December 1st, another $1,100 is going to be due, but this is just through November. Date for the writ is 10 days from today, which would be December 1st. No money judgment is issued at this time. Partial payment will not prevent the writ of eviction. And the defendant could be liable for additional damages like December's rent or other damage to the property. The appeal date is also December 1st. All right, so they're still there. Ms. Daler, you said you had no contact about this.
Mhm.
Have you
Yes,
had
sir.
other contact?
Yeah, I actually spoke to her this morning. We have
Okay.
pest control coming, so I reached out to her and let her know that this morning. And she has made a payment. She made a payment on November 1st, but she hasn't paid anything since.
That payment would have been included in what the numbers.
Yes.
I gave you.
All right, well, let's see what happens. I suspect perhaps they're going to pay the rent. All right, Mr. Thorne, does that finish our business?
It does.
All right, well, I'll see you on Monday the 1st.
Okay, thank you.
Thank you. All right, next is a case which is a blast from the past, which is entitled Bentwaters Apartments versus Carolyn Wise. Mr. Andrew Rognus is here on behalf of Bentwaters Apartment, and the tenant in the apartment, Stephen Boyer, is present. This is filed as a termination of tenancy. We dealt with this some time ago. The tenant actually on whatever lease there is Carolyn Wise. Then if there was a lease, it expired April 20th of 2025 and has become a month-to-month lease since that point. Mr. Rognus, what's the status here?
Actually, Your Honor, that September 30th it expired.
All right.
So what's transpired is back in June, Bentwaters had sent a renewal notice to Carolyn Wise, extending it through September 30th. We got something back with some scribbled signature on it, which now I suspect is probably Mr. Boyer's, but it's illegible. However, I would say you can't create a valid contract by accepting an offer made to another person in a circumstance where it's a bilateral offer. So Mr. Boyer actually is a stranger to this transaction. They switched out the notice to quit back on August 11th, asking him to move by September 30th. They have not accepted any rent for anything after that point in time. So at this point, Your Honor, I guess we'd ask that the court enter the judgment. He was personally served in the matter, and he's a stranger to this transaction.
That's not true.
Well, they're not, Miss Wadsworth is joining us. This came up several years ago. Mr. Boyer, how long have you actually lived there?
9 years.
And when did your mother die?
April 17th of this year.
I'm sorry, I thought it was sooner than that or earlier. So your mother died, you've remained in the apartment and you've continued to pay the rent since that time.
I've been paying rent for the last 5 years that I was placed on the lease by my mother.
So you're actually on the lease.
Yes.
Again, Your Honor, what I indicated previously, the offer was to Carolyn. and you cannot accept an offer made to another person. So in effect, there is no lease. I mean, that's first year contracts.
No, I guess I should have been told that.
You might find this hard to believe, Mr. Agnes, but I got the book award in contracts. I've probably forgotten
You
almost
mean
all
back
of it.
when they were still on clay tablets?
Yes, it was in cuneiform.
The code of Robbie?
Mr. Boyer, apparently they want to terminate this tenancy. You've lived there for 9 years. You've been paying your mother's rent for much of that time. She passed away in April.
Correct.
They served a notice to quit on you in August, asking you to move. And apparently they aren't interested in entering a new contract with you. I don't know all the background here. Jennifer Wadsworth, the manager, has joined us. You work for the Postal Service?
Yes.
I didn't know that.
Yeah.
So are you missing work right now?
Yeah, but that's, it's all they know. So, but yes, I am.
Well, what do you wish to do?
Well, I mean, I've been actively looking for a place to rent to get out of here, but I can't find anything. I've also gotten a loan to buy a home, but I can't find a home. And it's just it's a mess out there. You know, I just don't understand why it's such a hard thing to give a lease to somebody that's been here taking care of this place and paying the rent.
Well, it looks like it's well maintained just from what I'm seeing here. I don't know the answer to that, but I do agree there isn't anywhere to move to. You're better than many of our tenants. You got a good job. You got money to rent something else at market rates. You're even willing to buy a house.
Right.
But there isn't enough housing stock. Bentwaters has a waiting list of people waiting to get in there. I don't know all the background here. They could simply sign a new lease with you and you could continue to pay the rent and maintain your tenancy. Once they file the termination of tenancy, they can no longer accept your rent.
Okay.
So it's been several months, probably August, September, October, November's rent hasn't been paid.
No, it's
October and November, Your Honor.
Yeah.
Okay.
Which I have the money for, but
yes.
Your Honor, I certainly think that we probably could extend the same deadline that the last case did to December 15th.
All right. I'm not sure that under the law, I have to adjourn this matter at least 7 days. And we can't do that because next Friday court is closed. So our next available date is Monday, December 1st, which is going to be very busy. Under the law, you would get 10 days from December 1st to move out, which would be December 11th.
Okay.
Mr. Agnes is willing to extend it to December 15th, which isn't much of an extension.
Your schedule is overloaded on the 1st. Do you want to do it on December 5th?
Yes, December 5th ain't looking
that
too good
one
either, but let's take a look. Let's take a look. That would de facto give him until the 15th.
Yep.
Yes, that would be helpful, Andrew.
Okay. Time.
2:40.
Got it.
Mr. Boyer, you're not a tenant at sufferance. You're actually on the lease and you've been paying the rent when your mother was there for a number of years. And after your mother passed, you paid April, May, June, July's rent.
Right.
Then they extended some sort of offer to Carolyn Wise to renew the lease.
I never seen that. That came to me, so.
Well, they said somebody scribbled something on it and sent it back. I'm
Okay.
not sure what that means, but apparently they never extended an opportunity for you to renew the lease. As I said, I don't know all the background here, but as a practical matter, there's no current lease and they're asking to terminate this tenancy. So we're going to continue this matter until December 5th at 2:40. You can seek legal advice. You're probably not eligible for legal aid services, but you can seek other legal advice. That's the primary reason for the adjournment, according to the Supreme Court. But that would extend it to December 5th, which would give you until December 15th to move or be subject to being evicted. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. So I don't know, Mr. Rognus or Ms. Wadsworth, anything else to add?
Other than the fact, Your Honor, I got something dated September 13, 24. If I'm interpreting this correctly, it looks just like the initials SB. But again, that was to Ms. Wise, not to Mr. Boyer.
Well, they all were when I signed them.
Well, it isn't a secret. They know he's been there. He's not a stranger to them. So again, there's something more going on here than meets my eye. But Mr. Boyer, they want you to move. And you're in a fortunate position that you have a good job and a car and the wherewithal to do it. They're just trying to find a place to move to.
Yeah, right. That's true.
At this point, were you the only heir of your mother?
No, there's 3 of us.
All right. Your brother passed.
I have my youngest brother did, and then I have 2 older brothers.
Okay. All right. I wish I had a better answer for you, but we're going to revisit this on December 5th at 2:40.
Okay.
All right.
Thank you, Your Honor.
Thank you. All right, let's remove Mr. Boyer and get back to work. Ms. Wadsworth, nice to see you. All right, let's bring in iPhone, Brian Weiss, and we'll see if we get Mark Parker to take his hat off. All right, we've got Samantha Watts from the Phoenix 401k Trust. We've got Mark Parker, and we have iPhone. Mr. Parker, could you unmute your phone and your camera? And iPhone, who am I speaking with? Someone has joined us on an iPhone. Who am I speaking with?
Christy Keene.
All right. Mr. Parker, can you hear me? Well, I hope so. Mr. Parker, if you'd unmute your mic. I tried to unmute it. Mr. Parker, can you hear me?
Yeah, I got it unmuted.
All right, very good. All right, Ms. Keene, you can also hear me, and I'm going to advise each of you of your rights as a tenant in a landlord-tenant proceeding. Ms. Keene is here on a land contract forfeiture. And Mr. Parker is here on a demand for non-payment of rent. But in either case, You have a right to hire an attorney to represent you in this matter. If you can't afford an attorney, you could ask legal aid to represent you or seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court here at this first initial appearance or be prepared to file the demand in writing within 5 days of today's date and pay the $50 jury demand fee unless the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that isn't, well, that's, I guess, Mr. Parker's position. You may be able to get emergency housing assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a federal help for veterans program if you're a veteran. We did send that information to you with the original summons packet. You may be able to reach an agreement with the landlord by going through local community dispute resolution, also known as mediation. Both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed, which case they would file what's called a conditional order of dismissal. Our first matter is Phoenix 401k versus Christy A. Keene. This is a property, I believe, on 9th Street in Three Rivers, and it is a land contract matter. And Mr. Weiss, it looked to me like more than 50% of the contract price was paid. What's the circumstance here?
That is correct, Your Honor. Actually, there's a relatively small amount remaining on the contract. I'm showing that as of the date I filed the case, the total land contract balance as a payoff was $8,320.64. So it would be a 6-month redemption period in the event a judgment entered. The amount due in past due payments, which have not been made since June, I believe, plus taxes that were paid for the summer of 2025. So I'm showing the amount due of $59,3739. I've got court costs of $111.72. So the total balance I'm currently showing to redeem the property or the judgment amount would be $6,049.11. But that would be subject to a 6-month redemption.
Ms. Keene, I don't see a lot of land contract forfeitures where they've paid more than 50%. You paid about 80% of this property off, and you'd hate to lose it in a foreclosure or forfeiture. But when you paid more than 50% of the price, you have 180 days to redeem it, which is certainly better than 10 days in a rental position. What's your position?
Yes, sir. I will have the money on the 25th. And that would be for the $8,320.64, if that would be fine.
So you just plan to pay the whole thing off?
Yes, sir.
Well, I'm sure that makes them happy.
And she may need to confirm that amount now. I gave the balance as of the date I filed. There may be some additional interest, or I'm not sure if the taxes are included in that, but she can contact Ms. Watts to get the exact payoff. Current payoff.
All right, I think the safest thing to do would be to continue this rather than do some sort of conditional order of dismissal or something. The law says you're entitled to at least a 7-day adjournment. I would propose to adjourn this to December the 5th. And if everything is paid off by then, the whole thing can be dismissed. Mr. Weiss, are you available on the afternoon of December 5th at 2:45?
I'm looking at that as we speak. Friday. I should be, yes.
All right. Ms. Keen, this
Yep.
is the best case scenario. You pay it off, you own the property, there's no further land contract, the case is dismissed, and everybody lives happily ever after.
Yes.
If that doesn't work out, we'll discuss it further on Friday, December 5th at 2:45. In which case I would tell you how much is due because we'd have another month's payment for December. And then you'd get 180 days to redeem this, which would essentially be till next June. But it sounds like you've got a plan to pay the whole thing off. You'll own the house. And I say, good for you. Do you have any questions?
No, sir. Thank you.
Mr.
John, I would
Weiss, do you want
recommend-
her to
Yeah.
communicate directly with the trust?
That would be great. She could communicate with me as well, but if she wants to contact Ms. Watts to finalize the deal of payoff and get the exact redemption amount, or I'm sorry, the payoff amount, that would be fine. So she can contact either myself or Ms. Watts directly.
All right. Now, if it's all paid off, Mr. Weiss will do an order of dismissal by December 5th, and nobody needs to show up. If it isn't, we'll discuss it further on Friday, December 5th at 2:45. Is that agreeable with you, Ms. Keen?
Sounds perfect.
All right, very good. I hope I don't see you. Hope it's all paid off and everybody's satisfied. But it doesn't happen very often. All right. Thank you, Mr. Weiss. I'll see you again next time.
Okay, thank you. Have a good
All right, Ms.
holiday.
Watts,
Thank you.
Thank you. All right, let me bring in Mr. Davidson. Good afternoon, Mr. Davidson.
Happy Friday, Your Honor.
It's going pretty smoothly so far. Mark Parker is here with us. I've advised him of his rights as a tenant. But we were here last time on November 7th. And we continued the matter until today, which was 2 weeks. At the time we were here last time, we determined rent through November was $3,658 plus $185.40. Now you've given me some different numbers. Rent through something.
We just took the amount that was in the complaint, Your Honor, and then added 8 weeks to it. That's what I did.
All right, I thought we calculated that it was through, last time we calculated it was through November. So is this a week to week?
Yes.
All right. All right, Mr. Parker, they contend that rent at this point is $4,498.58. That would be through what date?
Today. Well, it's more than 8 weeks.
Through-
but 8 weeks is the rounded back.
Through today, through November 21. Mr. Parker, what's your position?
It's still under review, but now that they upped the rent saying that I owe, they're gonna need more. They're gonna need that updated amount. I'm not too sure. It's supposed to be month to month, so I'm not too sure why it's bouncing like that.
Well, let's take a look.
It was weekly at first, then he moved it to month to month. He was doing the same thing.
Yeah,
with
it's
my,
month to month.
Yeah, he was doing the same thing with my ex-girlfriend too. He would move it weekly and then he'd show it monthly and just bounce it back and forth like that. So I'm not too sure what exactly is going on. But it's under
Well,
review.
neither am I. The rent, the lease is month, well, it says 170 per week or 733 per month. So it's
Right.
either or on the lease, so I guess you can calculate it this way. When you say it's under review, by who?
DHS. So it's under review and I'll receive something in writing.
All right, well, you're gonna get this, you're gonna get this judgment. And you can take it to DHS. DHS often tells people, we need a judgment before we can give you financial assistance, which isn't accurate, but that's what they constantly, I hear it back.
Okay.
So you can take this to them, but each week it's gonna be another $177. Now, the other thing I told you before, I want to tell you again, partial payment will not prevent the writ of eviction. So you owe, with late fees, court costs, $4,943.98 through, we'll call that through November.
Okay.
Although I don't know, I'm troubled because on November 7th, I calculated that through the month of November, rent was $3,658.
Yeah, I don't understand.
That's what I placed on the record.
Well,
Now, Mr. Davidson put 8 additional weeks of rent on there, and we're still in the same month.
That's because you were calculating 170 a month, Your Honor, but at the time of the hearing, I said that I would provide you with the numbers today and you said, okay. So I didn't really want to go back and sort of beat that horse because my thought was that you had said that we should do it this way. Well, I know you said that we should do it this way and I did.
Well,
so I wasn't thinking it was a problem for today. That's the answer.
The complaint alleges that as of September 25th, it does say $3,138.58 through September 25th. So let's count that.
It's 8.1 weeks to today.
All right. Well, at least it'll give them a number from DHS to work from. Now, if they get the other problem, each week there's another week's rent due. So this is kind of a moving target because you get 10 days from today to pay this. That would be.
Another thing is he doesn't come bi-weekly. He comes around once a month. He doesn't come every week. He comes around to collect everybody's rent every month.
All right. Well, how'd you get so far behind in the rent?
I'm not too sure. He would come by weekly. I'd pay him a week. He'd come by monthly. I'd pay him half the month. And I had a bad abscess too, so I was out for a little bit. I had to have surgery on my jaw, so I was down for a little bit there. But he comes by once a month.
It's a relative concept.
Well, this is old school landlord where they actually come by your apartment to collect their rent. The wolf is at the door here, Mr. Parker. Hopefully DHS will give you some assistance. Excuse me, December 1st. Yes, have until December 1st to vacate or you're subject to being evicted. If you call the court, see, there's another problem. There's only 3 business days between now and December 1st. Next Monday, Tuesday, Wednesday. Then we got the Thanksgiving holiday and 2 weekends in the middle of that. So if you call the court and give them your email, we'll email you this judgment so you can share it with DHS.
Well, I'll do that right when I get off the phone here with you guys. I can do that.
All right, very good.
So I call up to the courthouse.
They agreed to give you $4,000, which is a lot. You would still owe the balance
of
$943.
Okay.
So you call the court as soon as we're done, and the clerk will email you a copy of the judgment so you can see it.
Okay.
And share it with DHS today because the clock is ticking. Now, they don't have to evict you on the 1st. They can, but they have 56 days from the day to ask for the writ of eviction. Again, if DHS is going to give you some money, that will be helpful, but the only thing that cures it is paying the entire amount.
Yeah.
And even, let's say it is monthly. On December 1st, you would owe December's rent. This is sort of half and half. It's half weekly and half monthly. I don't really like that very much. I'd calculate it through the month. Mr. Davidson calculated it by the week. But as of today's date, 11/20/25, that's how much your rent is. So you call the court, we'll email you a copy of this judgment. We can forward it to DHS if you tell us where, or you can share it with them, but I encourage you to do that today. Are you working someplace?
I work second shift at Morgan Olson.
That's what you told me. All right, so you're not missing work, but
No.
all right.
Who do I talk to at the courthouse? Who, just the clerk or?
Yeah, the civil clerk, and that number is 467.
On the judgment, it's 5541.
467 5505.
I would like to be able to get my rent paid because Paul is not a bad landlord. He's a good guy. He's, so I would like to get it caught up where I can, because he's a decent landlord.
Well, it's hard to find a place to move to. So you
It's
got a
very
good
hard.
landlord, you got a job. He can agree to work with you to get caught up on this, but 467 5505 is the clerk that you need.
Okay.
All right. Good luck, Mr. Parker.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Davidson.
Hope the rest of your day is so simple.
New baby boy Middleton was born this morning about, I don't know what time, sometime.
Congratulations.
Thank you. I don't know his name yet, but he has a lot of hair.
Good. That's always good for a healthy baby.
Okay. All right. Thank you.
Congratulations on the new edition.
Yes, thank you. That may be the last grandchild I'll have. I never envisioned myself as being a grandfather, but I'm all over it right now.
I know you're great.
All right, our next matter is set for 10:15, which is 4 minutes from now. The defendants are here with me in the courtroom. The manager, Ms. Cousineau, is here. I ran into her the other night in 3 Rivers and she didn't recognize me outside of court. But it was nice to meet your sister.
Outside.
We did terribly on our trivia that night, so we're sinking lower to the bottom.
Is that like a board where you go every week? Or is it?
Sometimes the trivia is on Wednesday nights, and I go with my son and a couple others. It was his birthday, so we had some extra people with us. But yeah, it's every Wednesday, and each Wednesday I get dumber and dumber.
That's fine. That's why we went. She took me out for dinner for my birthday.
We have the same birthday as my son.
I was the 18th.
Oh,
Close enough.
close enough. All right, all we need is Mr. Butchart, and we can address this matter. Mr. Havens and Ms. Patnod, why don't you come up and have a seat? Right over here where you were before. Good morning. That happens to me a lot, and it has ever since people would see me and they'd say, I know that guy from somewhere. But most of the time people say hello. They just call me by my first name, but I lost that when I became judge. So generally when I go somewhere, people often just say hello.
Yeah.
All right, we have just one of these. I think we have another one. Oh, just this one. Oh, we have an 11 o'clock. Ledford. So we have 10:15. Then we have a break until 10:40. So we may take a short recess. Then we have a 10:40 and 11. And then we have a full afternoon. Here's Mr. Gromer.
Officer Evans?
Probation would recommend moving forward with granting the judicial release, placing Ms. Rao on a period of community control, having her complete outpatient treatment to address substance abuse and mental health, and placing her on a period of ankle monitored curfew.
Mr. Kilburn?
Judge, we'd ask the court adopt that recommendation. She's got support lined up, we think, given the circumstances, no criminal history, and her compliance and her progress in prison. She's certainly worthy of that. We'd ask the court follow that recommendation.
Ms. Rao, anything you want to tell me?
I'm honestly very grateful for this opportunity that I had to sit down. I am very grateful that this turned my life around. I really believe that I'm not going to go back to this lifestyle. I can't for the sake of society, for my family, for myself. And it was hard. It was really hard, but it was something that I needed to go through.
All right, the court's going to grant the motion for judicial release. I am going to place you on 3 years of basic probation. I'm going to order that you enter into and successfully complete drug and alcohol treatment. You're going to be on 90 days of electronically monitored supervision with a curfew, 30 days, and you'll be subject to the remainder of the standard rules of probation. All of the other orders of the court remain in full force and effect. Anything else?
No, sir.
The monitor is 30 days, Judge?
Yes.
Thank you.
All right, good luck to you, Ms. Rao.
Thank you so much, Your Honor.
Good morning, Your Honor. Gabriel Lacey for Arbor Meadows.
Dual? Are they checked in? They're not here. If you raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. At this time, this is a non-payment of rent case where the tenant past due rent of $1,020.53, court cost of $176.32. Total outstanding balance is $1,196.85. We are asking for a pay or vacate date of December 1st, 2025.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Arbor Meadows versus Pedro Quijada.
Gabriel Lacy for Arbor Meadows.
Quijada, they are not here. You may proceed.
Thank you, Your Honor. At this time, this is a non-payment of rent case where we're asking for a possession-only judgment in the amount of rent to retain possession is $2,363.25. Court cost of $176.32. Total outstanding balance is $2,539.57. We're asking for a pay or vacate date of December 1st, 2025.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested, writ issue in 10 days.
Thank you, Your Honor. Have a wonderful day.
That's it for you?
Oh, wait, hold on.
I got one more.
I got one more too, Your Honor. I'm sorry. I thought that was my.
You're just gonna get out of there because you're going to try to eat those jelly beans on your desk.
Oh my God, it's my peanut M&Ms, Your Honor.
So no, what I'm saying is next time you show up in person, there's
I'll
a
make
whole
sure I have some
courtroom of
for you.
people that would probably like jelly beans, but you do what you're gonna do, Miss Lacy. Court does call the case of Beal Properties versus Alexis Bland.
Gabriel Lacy for Bill Properties, Your Honor.
Alexis Bland, they are not here. You may proceed.
Thank you, Your Honor. This is a non-payment of rent case where we are seeking a possession-only judgment where the rent to retain possession is $1,004. Court cost of $175. Total outstanding balance is $1,179. We're asking for a pay or vacate date of December 1st, 2025.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with the writ issue in 10 days. Let me get these out of the way. Arbor Meadows versus Scrotenbauer. And Arbor Meadows versus Maya Valdez. And Manchester Manor versus Jessica Strohmeyer. Steiner, I think it actually is. Those matters are dismissed on plaintiff's motion without prejudice. Now you can go.
Thank you, Your Honor. Have a good one.
All right, Miss Lacy, take care. Evergreen Apartments versus Lavina Kendricks Haynes.
Good morning, Your Honor. Jillian Engen for plaintiff. An access point.
Is she? Oh, yep, there she is.
I'm going to send Alex to her.
Ms. Kendricks Haynes, can you unmute? Sending. Oh, there you go.
Okay.
All right, you're there.
Thank you.
All right, you're welcome. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $3,208.85.
All right. Ms. Haynes, how are you intending on getting that paid?
I have some agencies going to be helping me, Friends Indeed. I also applied for assistance through Department of Human Services and Jewish Family Services. And then I have some more lists of places too that are supposed to help me, but they said like it takes a period of time. It's like maybe a week to 7 days or something like that for the application to be reviewed.
So first thing you need to do is if you applied for an SER or other assistance, there's a form that came in your packet that's called a rental assistance form.
Okay.
You need to fill that out with all of that information, particularly the tracking number if you had an SER, and submit that to the court by Wednesday.
Okay, I can do that.
Okay. And I will adjourn this matter out then to allow you to do that. We'll have to go 2 weeks out because I'm not coming in the day after Thanksgiving.
All right.
I'll adjourn it out to December 5th,
Okay.
2025 at 2 p.m.
All right. Thank you.
All right. Thank you, ma'am.
All right.
Court does call the case of Evergreen versus Dustin Mickle.
Jillian Engen for plaintiff.
And go ahead. I'm sorry.
Oh, sorry. Jillian Engen for plaintiff.
And also Antoinette Mickles. Oh, there she is. All right, Miss Mickles.
Hello.
Hello. All right, what is plaintiff's claim?
I have a balance including court costs of $3,262.38.
All right, Ms. Mickles, how are you intending on getting that paid?
Me and my husband, we talked to Hawk, and we have another appointment with them on Monday at 12. And then I've also put in the SCR through DHS.
All right. So what I will do is I will adjourn this out then to December 5th, 2025 at 2 p.m. I don't know if you heard me on the last case. There's a form that came in your packet called a rental assistance form.
Yes.
You'll need to fill that out along with the tracking number, particularly for your SER, and also indicate that you've applied to Hawk. Okay. And submit that to the court by Wednesday.
Okay.
Okay.
All right.
All right. Very good. Have a great Thanksgiving.
You too.
Let's call the case of Evergreen Apartments versus at the call. Let me just do the last name. Adeboale.
Yes, Your Honor. I'm here. Yes, Your Honor.
Okay. You were watching me. You were just going to watch me struggle, weren't you?
Well, I did want to interrupt you, Your Honor.
No, you could. Oh, I'm struggling. You could have interrupted. How do I pronounce your name, sir?
It's Adekolapo Adeboale.
Yeah, that probably wasn't going to happen this time of morning. All right. Okay. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $2,632.32.
All right. And sir?
Yes, Your
How are you
Honor.
intending on getting that paid?
So, honestly, Your Honor, I'm struggling right now. I lost my job currently. I do not think I could afford to stay in the apartment. I'm willing to move out peacefully. And I'm asking for a dismissal with consent so it does not appear as an eviction on my record.
Got it. Here's what I'm going to do. If you're going to vacate the premises, I'm going to suggest you call the attorney's office. You'll have to turn in your keys. When were you looking on moving?
I was hoping you could give me as long as I can, but I was hoping for a court that you set, Your Honor. So a date that you set.
All right. Why don't here's what I'm going to do. I'm going to adjourn your case out to December 5th, 2025 at 2 p.m. That's an in-person hearing. But if you vacated prior to that time, I'm sure, well, they're only asking for possession.
Okay.
So then what would happen is they would end up dismissing the case. You would still owe money, but they wouldn't be taking a judgment at that point. Okay. What I'm going to suggest that you do, though, is contact counsel's office, which is the numbers on your paperwork, and see if you can arrange how that's going to occur and everything, and the things certainly that you need to do before leaving the place. Okay.
Understood.
All right. Okay. Thank you, sir.
Thank you, Your Honor.
Thank you.
Evergreen Apartments versus Kayla Smith.
Jillian Engen for plaintiff.
Hi, Kayla Smith.
Oh, there she is. Hello, Miss Smith.
Hello.
All right. How much is owing?
I have a balance including court costs of $2,842.63.
All right. And Ms. Smith, how are you intending on getting that paid?
I'm going to make a payment of at least $1,500 next week. Hopefully the whole thing. But if not, then I'm going to work on the rest.
All right. At what point next week, do you know?
Next Friday.
Okay. By the, what is it, the 28th?
Next Friday, yes.
Okay. So I'm going to mark the file that you're going to pay $1,500, maybe the whole thing by next Friday. Okay. What I will do
Set a reminder for December
then
4th
is I'll adjourn it out to December 5th, 2025 at 2 p.m. That's an in-person hearing, so if everything's not paid, you'll need to come down to the courthouse, okay?
Okay.
And I should say this also, is if you can make the payment of the whole amount that's due prior to the end of the month, that would be the best thing, because then December won't click in, they'll dismiss the case, and then you can work toward December. Got it?
Okay.
Otherwise,
Yeah.
by the 5th, December is going to be a problem.
Right.
Okay?
Okay. Thank you.
All right. Thank you. Have a great Thanksgiving.
You too.
Evergreen Apartments versus Christopher Hesterly.
Jillian Engen for plaintiff.
There he is. Mr. Hesterly's there. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $2,203.36.
Give me that number again.
$2,203.36.
And Mr. Hesterly, how are you intending on getting that paid?
Yep. So next week I get paid. I should be getting paid around like 1,200. And right now I have about, I want to say maybe 300. And my dad is supposed to help me with the rest. So I'm trying to have it all paid by next Friday. I think the way how my check might come with some of my money, it might get pushed to Saturday because of the holiday. But if I can have up to Saturday, I think I will have it all paid.
Okay, let's do this. So you got 300 that you can pay now?
Yep.
Okay, and then next week you think you'll have about 1,200?
Yep, I think my check will be 1,200 for sure. And
okay,
then,
and how much of that are you going to be able to pay?
I believe the whole 12.
Okay. So then I'll put 1,200 and I'll put that by the 28th. Okay. And then you've got others that are maybe going to help you out. So if you can get everything paid by that before the end of the month, then like I said with the other young woman, then the case will be dismissed. Otherwise, we're going to click over into December. December is going to be due.
Correct.
Got it? Okay. But what I will do is I'll adjourn this out, get those paid. I'll adjourn this out to December 5th, 2025 at 2 p.m. That's an in-person hearing, so you'll have to come down to the courthouse if everything's not paid up, okay?
Okay.
All right. Thank you.
Thank you.
Have a great weekend, great holiday.
You too.
Okay. Evergreen Apartments versus Tracy Coleman.
Jillian Engen for plaintiff.
Tracy Coleman.
Hi, Your Honor.
Oh, she's not coming up on my screen. Can you speak again, please?
Oh, yes. Hello, Your Honor.
Okay, there you are. Okay. Okay. Well, how much is owing on this case?
I have a balance including court costs of $1,602.98.
All right. And ma'am, how are you intending on getting that paid?
It'll be paid by the end of the month, sir.
So you'll get it, the whole balance will be paid by the 28th, you think?
Yes, sir.
Okay, I'll mark the file that way. I'll adjourn this out to December 5th, 2025 at 2 p.m. If it's not all paid, then what will happen is you'll need to come into the courthouse on that date and time. Okay?
Yes, sir.
All right, thank you.
Thank you.
Have a good one.
You too.
Evergreen Apartments versus Tia Wright.
Jillian Engen for plaintiff.
Tia Wright is here.
Okay, I'll need a camera, Miss Wright. She's here. There you are. Okay. How much is owing on this case?
I have a balance including court costs of $3,097.15.
All right. Ms. Wright, how are you intending on getting that paid?
I do have half of that. I'm trying to wait because I applied through DHS for the SCR, and I also reached out to Hawk. So I'm trying to hear what if they're gonna help me. But I do have half of that.
Okay, let's do this then. So you got about 1,500?
Maybe a little less, but yes.
A little less? Okay, Ms. Wright, how much do you have?
I want to say like maybe 1450.
Okay, so right under the 15. All right,
Yeah.
let's do this. I'll indicate, I don't know that she says she really has the 50, so here's what I want to do. Or no, I think she's keeping the 50 for Thanksgiving. That's what I think. No, I'm just messing with you. So what I'm going to do is pay the $1,400 to the landlord. Okay. Get that paid by Monday, let's say. Okay. Then what I'll do is I'll adjourn this out to December 5th, 2025 at 2 p.m. Try to get everything. Have you applied to Hawk already, ma'am?
No, because I didn't get my actual court document until Wednesday.
Okay. All right. So make sure to contact them. If you can, contact them today.
Okay.
If you applied for the SCR, there's a form in your packet called a rental assistance form. You make sure to fill that out, get that down to the courthouse by next Wednesday.
Yes, sir.
All right. Okay. Fantastic. Thank you. Have a good holiday.
You too. Bye-bye.
Evergreen Apartments versus Hadassah Figueroa and Susanna Figueroa.
Jillian Engen for plaintiff.
Hello, Your Honor.
Hello, Ms. Figueroa. All right. How much is owing on this?
I have a balance including court costs of $989.74.
All right. Ma'am, how are you guys intending on getting that paid?
I get paid next Fridays, which is over about $1,200. So I intend on making the balance zero by the next weekend.
Okay, so by the 28th, which is next Friday, you intend to get this paid?
Yes, Your Honor.
All right. What I'm going to do is I'm going to indicate the balance by the 28th. I'll adjourn this out to my next date of December 5th, 2025 at 2 p.m. If you've got everything paid, then you probably won't need to appear at the courthouse on that date because they'll be dismissing the case. Okay. But just make sure everything's paid and that you're down to zero before the end of the month.
Will do. Thank you, Your Honor.
All right. Thank you. You have a great holiday.
You as well. Bye.
Evergreen Apartments versus Carnell Harbin.
Jillian Engen for plaintiff.
Now checking.
Carnell Harbin. They are not here. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $1,975.85. Court costs are $172 for a total of $2,147.85. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days, which I have is after December 1st, 2025.
Yes. Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. Glencoe Hills versus Willie Williams.
Jillian Engen for plaintiff.
All right. Mr. Williams, can you get your, can you unmute there?
I'm gonna send Alex.
All right, we're sending somebody in to help you out.
Can you hear me?
Oh, yep, you got it. All right. Good job. All right. How much is owing?
I have a balance including court costs of $1,641.83.
All right. And Mr. Williams, how are you intending on getting that paid?
Yesterday I spoke with the manager about a little extra time at getting this all paid. I start a second job. I'm supposed to get the results from a criminal background today, and so I'm hoping to start a second job this weekend. I do have, and that pays every week. So
Okay.
I'm hoping I can get everything paid off by the end of the month. I do have $500 on me right now.
Okay, let's do this then. Get the $500 paid today to the landlord.
Yes.
Okay, so we get that in. And then if you won't know in terms of the job or whatever. So what I'm going to suggest that you do though is contact the attorney's office that's on your paperwork, the number that's there.
Yes.
And see if you can work out a payment plan and give them exactly how you plan on paying it out or paying this down and off. Okay.
Okay.
So I'll adjourn this out to December 5th, 2025 at 2 p.m. And Mr. Williams, if we can get everything paid off before the end of the month, that'd be great, or get some agreement. If we can't, then you got to come down to the courthouse. Well, you're already down here, so you know how to get here. You got to come down to the courthouse, and we have a hearing on that date in person, okay?
December 5th.
Yes, sir, at 2:00.
Okay, I got you.
Okay. Let's see if we can get it done before the end of the month.
Okay,
Sounds like you got a plan.
All right.
All right?
Yes, sir.
Thank you, Mr. Williams. Have a good Thanksgiving.
You as well.
Glencoe Hills versus Devin Allen. And Danielle Allen.
Jillian Engen for plaintiff.
Who do I have? Oh, there he is. What is he wearing? He's got Michigan stuff on?
Yeah.
Why do they have that on? They're very confused. They don't understand I'm a Maryland grad. This is not the day to do that.
All right.
That's right. You lose. No, I'm kidding. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $1,329.
All right. Hey, Mr. Allen, how are you intending on getting that paid, sir?
We'll have that paid on the 26th of next week.
The 26th?
Yes.
Which is the day before, on Wednesday?
Yeah.
All right. So I'm just going to put the balance by the 26th. If you get that paid by that date and everything's paid off, they're going to dismiss the case out. Otherwise, what I'm going to do here is I'm going to adjourn this to December 5th, 2025 at 2 p.m. That's an in-person hearing. So if for whatever reason you don't have it paid off, you've got to appear, and then we've got to then deal with December too. Okay?
Okay. Thank you.
All right. Thank you, sir. And not go blue.
Go.
Bye.
Have a great day.
Take care. Court does call the case of Glencoe Hills versus Ollie Hicks.
Jillian Engen for plaintiff.
Ollie Hicks, they are not checked in. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,463.12. Court costs are $171 for a total of $3,634.12. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days, which I have is after December 1st.
Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested with the writ to issue in 10 days. Gulfside Lake 1 and 2 versus Michael, is it Perguidi?
Jillian Engen for plaintiff.
Oh, I think he's here. Also in that Michigan stuff.
Sorry about that.
No, it's okay. You root for whoever you want. I guess. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $1,538.87.
All right. And sir, how are you intending on getting that paid?
I did already pay was 500 of it, and I plan to pay the rest on the November 26th.
Okay, on Wednesday.
Yes.
Okay, so you paid 500 of this amount, you think? Do you see that, Miss Engine?
Let me check. I see that there was a payment on the 12th, but Mr. Peregrine, is that are you talking about a different payment that was made recently?
I think so. I looked at my balance and it said 1,148 when I looked.
Okay, what, did you make the payment yesterday?
No, I did make it. It was last week I made it.
Last week. Okay.
Okay.
Well, we can figure that one out.
Yeah. Here's what I'll do, sir. If you're gonna get everything paid by Wednesday, next Wednesday, I'll indicate that in the file. And then I'll adjourn this out to December 5th, 2025 at 2 p.m. That's an in-person hearing.
Okay.
But if you've got everything paid off, then I don't need to see you. Okay?
Okay.
Just make sure everything is paid off before the end of the month.
Yes, sir.
And Mr. Peregrine,
All right.
you can talk with Melissa and make sure that, everything's good.
Okay. All right. Thank you so much.
All right. Thank you, sir. Have a great weekend and holiday.
Thank you. Bye-bye. You too.
Gulf Side Lake 1 and 2 versus Anika Howell.
Jillian Engen for plaintiff.
And Kayel Howell. Howell? Nobody's here. You may proceed.
Hello, Your Honor.
Oh, maybe she's here. Okay, I don't see. What is your name?
Anika.
Got it. Okay. All right. What is the claim on this case?
I have a balance including court costs of $2,856.
Okay. Ma'am, how are you intending on getting that paid?
I got my balance down to $2,206 as of this morning. I was gonna reach out to some agencies. I also just got a new full-time job that I just started this week. So I was just gonna ask for a little bit more time. I did show Melissa the proof of me getting my new job that I just started.
Okay. So how much did you pay to get your balance down?
Yesterday I paid $125, and this morning we paid $500.
Okay.
And I've been making payments every time I got paid.
Got it. Okay. So you don't know when the next time you're going to make a payment though, right?
I get paid every Wednesday with chime. Wednesday or Thursday with my chime.
Okay. So next week, how much can you pay, you think?
I could try to aim for 300. I don't know how much.
Okay, that's fine. That's fine. I'll just put 300 by next Wednesday, by the 26th. Okay, the day before Thanksgiving, or by the 28th. Get it in, okay?
Okay.
And then if you apply to agencies, like you try to do an SER through DHHS, if you apply to Hawk, I'll need you to fill out the form that came in your packet called the rental assistance form.
Okay.
And fill that all out, and then you have to file that with the court by next Wednesday.
Okay.
Okay? And always feel free to contact the attorney's office to see if you can work some payment plan out if it doesn't look like you'll get it clear before the end of the month, okay?
Okay.
So I'll adjourn this out to December 5th, 2025 at 2 p.m. That's an in-person hearing, so if you don't have it paid off, I'll need you to show up at the courthouse.
Okay.
All right.
Thank you, Your Honor.
Thank you. Thank you. Have a good Thanksgiving.
You too.
Court calls the case of Bonnie Jacques.
Morning, Your Honor.
I'm sorry, Gulfside Lake, this label, you gotta deal with this. Gulfside Lake 1 and 2 versus Bonnie Jacques and Brandon Jacques.
Jillian Engen for plaintiff.
They're usually here. Oh,
Mr.
Brandon's.
Good morning.
Good morning, sir. You don't have a camera, but I think you turned it on, but it's covered. All right. How much is owing?
I have a balance including court costs of $2,965.36.
All right. And sir, how are you intending on getting that paid?
I'm currently working with my employer to get it get paid so that I can pay the balance before the end of the month.
All right. So you think you're going to have the balance paid before the end of the month?
That's what I'm working towards, yes.
All right. So here's what I'll do. I'll adjourn this out. I'll mark the file that that's what you're intending on doing. I'll adjourn this out to December 5th, 2025 at 2 p.m. That is, Mr. Jacques, I think you're aware, an in-person hearing, you'll need to come down to the courthouse unless you have everything paid off before the end of the month. All right?
What was that balance again? I'm sorry, just so I can be sure.
I've got it.
I have
you have it.
$2,965.36.
Okay, thank you.
All right, thank you.
Have a good one.
Gulfside Lake 1 and 2 versus Chloe Luke and Nura Jones.
Jillian Engen for plaintiff.
Luke, Jones, they're not here. You may proceed.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $2,671.41. Court costs are $214 for a total of $2,885.41. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days, which I have is after the 1st of December.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Gulfside Lake 1 and 2 versus Lakia Williams and Karan Williams.
Jillian Engen.
There she is. No, she's here.
Hello.
Hello, Miss Williams. All right. If you have a camera, that'd be great, but let's do this. What is the claim?
I have a balance including court costs of $2,785.11.
All right. And ma'am, how are you guys intending on getting this paid?
Well, like last month, me and my roommate both lost our jobs, and then my sister got into a bad accident. So we've been working on trying to like find jobs, and then he found one and he starts in 2 weeks and I start in 1 week, but my mom is willing to give us $1,500 in 2 weeks to put on the balance to help.
Okay. All right. There was a lot packed in there. It's okay.
Sorry.
No, it's okay. You got a plan. So when did you say your mom was going to have the 15?
2 weeks from today.
Gotcha. Okay. So that's going to be into December. So that's okay. It's all right if we can get that paid. And then, have you applied for assistance like through Hawk or something?
So I lost my job earlier this year and Hawk helped me out, but when I talked to them, I believe they said I could only get help like once a year.
Yeah.
Yeah.
Okay. All right. Okay. So let's do this. I'm going to adjourn this out to December 5th, 2025 at 2 p.m. That's an in-person hearing, so you'll need to come down to the courthouse. What I'm going to suggest you do is contact plaintiff counsel's office, see if some type of an agreement or conditional order dismissal can be worked out where you can get this all paid off. Okay?
Okay.
Does that sound all right? So that at least sounds like a plan. If you apply for any other assistance, make sure to fill out the rental assistance form and get it to us by Wednesday. Okay?
Okay. Yes.
All right. Very good.
Thank you.
I've set that. You take care. Have a good Thanksgiving. And I hope your sister is doing well.
Thank you very much.
All right. Take care. Gulfside Lake 1 and 2 versus Alicia Sar.
Hello.
Where is she? Oh, there she is,
Yes.
down at the bottom of my screen, just yelling hello. No, hello. How are you doing?
I'm good.
All right. What is plaintiff's claim in this case?
I have a balance including court costs of $2,016.26.
All right. And how are you intending on getting that paid?
So I did apply for assistance, but I'm still waiting to hear back. And then I plan on having it paid off by the 29th, though.
All right. So you applied through?
For SCRD, DHS, I think.
Okay. So you applied for an SER?
Yes.
All right. But you hope in any event to have the balance before the 28th or the end of the month, basically, right?
Yep.
Okay, so here's what I'm going to do. I'm going to adjourn this out to December 5th, 2025 at 2 p.m. If you have it all paid off before the end of the month, you may not have to appear. Otherwise, you'll have to come down to the courthouse on that day. Because you applied for an SER and other assistance, you need to get the rental assistance form, which is in the packet, fill that out, and get that to the court by Wednesday.
Okay.
Okay?
Thank you.
Thank you very much. You have a good holiday.
You too.
Court calls case, Gulfside Lake 1 and 2 versus Natasha Olmos.
Jillian Engen for plaintiff.
Almost, she's not here.
Yeah, I'm here.
She is? Where is she?
Yes.
Oh, there she is.
Hi.
Okay.
Good morning.
Hello. Good morning. Okay, what is plaintiff's claim?
I have a balance including court costs of $4,225.79.
You said 4275.79?
4225.
4225.
Yes, sir.
All right, Ms. Olmos, how are you intending on getting that paid?
So I had some student loans and grants coming. It's supposed to be here November 27th. It was applied to my account on the 19th, but it takes about a week to hit my account. So I plan to have it paid by the end of the month.
Okay, you got, all right. Okay, so what I'll do is I'll indicate that your intent is to pay the balance by the 28th or thereabouts, right?
Mm-hmm.
And then I'll adjourn this out to December 5th, 2025 at 2 p.m. If you don't have it paid, we'll need to see you down at the courthouse. But if you have it paid, they're going to dismiss as long as you get it paid before the end of the month.
Okay. And if I do need to log in, you said, okay, so if I don't have it paid, come down there. Because last time I didn't have the Zoom link for the next court date.
I'm sorry?
So if I don't have it paid, I come down in person, right? So there's no Zoom.
It's an in-person hearing. Yes. Ma'am.
Okay. All right. Perfect. Thank you.
All right. Thank you, Ms. Olmos. You have a great holiday.
You too. Thank you.
Gulfside Lake 1 and 2 versus Samantha Gonzalez.
Jillian Engen for plaintiff.
Samantha Gonzalez, not here. You may proceed.
Thank you. I have a balance including court costs of, I have rent to retain possession of $2,527.53. Court costs are $172 for a total of $2,699.53. Plaintiff is requesting a default judgment for possession only with the writ to issue after 10 days, which I have is after December 1st, 2025.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Peninsula Place versus Amadou Diane.
Jillian Engen for plaintiff.
See here? Oh, he is. Amadou Diane.
Yes.
Oh, there you are. Oh, kind of there you are. All right. He's there. Well, can't see you yet. There we go. We got you. Well, I don't know why you won't stay. There you go.
Yes.
All right. What's plaintiff's claim?
I have a balance including court costs of $2,731.06.
All right. Diane, how are you intending on getting that paid, sir?
Because I do owe that, and I'm gonna drop off a $700 today. I mean, life's going on right now, and I'm planning to pay that on the 5th, remaining balance of that by the 5th.
By the 5th?
Yes.
Okay, so unless there's some other arrangement, your December rent is gonna be included in that.
Yeah, that's the only thing that I'm kind of worried of right now. But I will pay the 7.
Good morning.
Morning.
We've got everybody we need here. Mr. Havens and Ms. Patnod are here with me in the courtroom. Your manager, Lori, is present, and now you're here. The file number here is 252069LT. It's entitled Village Manor versus Patnod and Havens. It's filed as a termination of tenancy for alleged number of lease violations. When we were here last on November 14th, the defendants indicated they enjoyed living there and had been there for a number of years, and they would move if they had somewhere to move to. So who's going to speak for you two?
I will, sir.
All right, Mr. Havens.
Better than Mr. Patnod. Good morning, Your Honor. Good morning, Lori. Good morning, Mr. Groomer.
Good morning.
I spoke with Lori and Mr. Groomer on Friday and Monday, and we have come to agreement, or they've come to help me out along with a conditional order of dismissal.
That's
and
correct,
that way
Judge.
I won't have the eviction on our records, and we'll get out and their time.
All right, Mr. Gromer, what are the terms of it?
Judge James Cromer, P63503. Yes, I've met with Mr. Havens, and I hope I don't mess up her name, Ms. Patnod. We have agreed to a conditional dismissal with a move-out date of December 31st, 2025, Your Honor. I have explained to both of them that they're not represented by an attorney. They do have 3 business days from which to ask the court to set this aside if they believe a decision, something was incorrectly done. And I have also explained to them that if they don't move on or before that date, the court could reinstitute the case and ask for a writ. It seems like them and the property are working together. Great judge. They also granted me permission to sign their names. I have confirmation in an email from them.
Is that correct?
Yes, sir, it is.
Could you email that to me, Mr. Gromer, and I'll provide a copy of them before they leave.
Yeah, I'll have my office send it right this minute.
All right. The email address is on the notice, but it's 3bcivil@stjosephcountymi.gov.
All
and
right.
that way they can walk out of here with a copy of that in their hand. All right. So you agree, you're going to move by December 31st.
Yes, sir.
All right. That's at least 20 days more than the statute provide for. And a conditional order of dismissal means it will not show as an eviction on your record, which could be very important.
Yes.
In the long run. If you don't comply with it, they could ask for a reinstatement of the complaint and issuance of an eviction order. You understand that?
Yes, sir, I do.
And you said this, and people have said it several times already today. We'd move if we had somewhere to move to. If you had any luck finding a place?
I checked on 2 places yesterday that I'm on a waiting list, and they said, just hang in there, hang in there. They say there's people ahead of me, but you know, people move, people pass away.
Everybody's got a waiting list.
Yeah.
Including Miss Cousineau. All right.
I appreciate you, Your Honor, and I appreciate Lori and Mr. Groomer. At least we'll have a Thanksgiving dinner at home still, and maybe even put up a Christmas tree. So
all right.
It'll be great. Thank you all.
Yes, it's all a sad circumstance. All right. If you go out to the counter, I'll sign this. I'll give you a copy of the order, and then you're good to go.
Thank you, sir. I appreciate it.
Thank you.
Happy Thanksgiving.
All right. Thank you. Mr. Gromer, you guys aren't up again until 11. I'm going to take a short recess here, and I'll see you in a little bit. I've got another case at 10:40. So I'll see you in a bit.
All right, Your Honor, just for the record, we thought we had an agreement principle with the 11 o'clock, but we've now.
Oh, we do have that one settled also.
But I've not now been able to reach her in
All right.
5 days, so I'm not sure if she's appearing or not.
Well, we'll find out. If you have an agreement, send that too, and then I can address it.
I don't have it signed, but I'll send the blank one, Judge.
All right, that's helpful. All right, I'll see you in a little bit.
Thank you.
All right, we'll be in recess and we'll see if anybody.
Pleasant change. Demarion Kelly. Demarion Kelly.
He said, thank you, Judge. We sent the paperwork.
Thanks.
Please. Thank you, Judge. Good morning. Good morning. Huh?
You don't need to thank me. I sneeze by nature. Nature doesn't want to sneeze.
He needs to sign it. Bad.
Oh, my bad. Perfect.
We now call cause number 24, CR 1673, the state of Texas versus Demarion Dwayne Kelly. That's you?
Yes, sir.
With your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment?
Yes, sir.
And the arraignment here? Can we proceed in the summary?
Yes, sir.
Fine.
Yes. Please. It's one of the doors that
In summary, this indictment alleges that on or about March 30th of last year, 2024, in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you are charged with here? A state jail felony means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment rate, sir?
Yes, sir.
Scratches here. An agreement has been reached. Oh, that was close.
You said it was close, huh?
Yeah, boy, on the restitution, that would have been a 3rd-degree felony for another 1,000 loss. Just come up with number 2 here along with this. Unable to understand the TDW. If convicted of a state jail felony, I told you what the punishment range was. And in this case, an agreement has been reached where you would be sentenced to 2 years in a state jail. That would be suspended. You would be placed on regular probation for 5 years. Most important thing is you got to pay this money back. Whatever happened to the items here? I'm asking you. Where are they?
The person that used me to rent the stuff, they sold it, I guess. And I didn't realize that until later on. So what was going on?
Oh, so you're not guilty?
I'm not saying that. He's guilty.
I am, but
he worked with us.
Yeah, I am, but doesn't get it, sir. You're either guilty or not guilty in this room. You don't, I'm not guilty, but no, you're either guilty or not guilty. If you're not guilty, we'll have a trial. That's what we'll do and let a jury decide. They don't give probation.
those go to jail.
No, I just, look, you're hedging. You're hedging. You're not, you're charged with theft. You're not going to trick me or try to deceive me. You may try to deceive others here, but no, I've got my hand on my wallet at all times here, keeping it safe. Sir, you're being a smart aleck, is what you're being, sir. I've asked you what happened to this. What I want is the people to be paid back for their loss. If you have the items, I want you to give it back to them, whatever it is you rent.
It's heavy equipment.
Whatever, I'm still unclear. Where did it go? You give it back to them, you don't have to pay restitution.
He said it was sold.
You sold it to somebody?
He sell it. The person that went to jail for it sold it.
There was two people involved.
I was used to use my ID to rent the machine, and I didn't realize till later that what I was doing was totally wrong. Uncle, I don't know if Beaumont picked him up or whoever picked him up, but he's currently in jail for it now.
Who?
You want
to know his name?
Oh, Jerome Daniel.
Did he get charged?
Yes, sir.
Is that in my court?
I don't know.
Jerome Daniel?
What's it up?
Did it wrong. Last name is Daniel.
Daniel.
That's your heart.
I'm not seeing it either.
That don't work. Try Jerome Terry Denton. So,
DRRY.
yes, ma'am.
What does the state have in your file on evidence in this case?
Your Honor, we have the contract from JAC Rentals where this equipment was.
May I see that? What else do you have in there?
An office report, photos of the materials.
Driver's license? Worst thing you can do is attempt to mislead me or stand up here during any process that we handle in this court and make a false statement. That would be the worst thing you could do. And I'm going to find out if you did that or not. Because it's somebody else who used your ID is what you've told me.
Yes, sir.
We'll see, because they say it was you in this affidavit.
Yeah,
It's not a debate. I'm going to just let me get the information and what your story is you had no knowledge that somebody else was going to use your ID and rip this, correct?
Yes, sir.
So quite naturally, you got indicted by the grand jury for no reason. Let's see how that plays out. Because the worst thing you can do is get caught in a lie in front of me. What's his bond? Because false statements to this court are crimes.
No, 5,000.
Your Honor, I have the contract with his contact information, but I'm not seeing a copy of his driver's license.
Give me your driver's license.
Oh, it's in the car.
Go get it.
Do you have media?
Yeah, I do have media.
And come right back, or else a warrant will be issued for your arrest. Thank you. I don't know. You might want to talk to him because he's digging a hole.
Let me go outside. Well, he's coming back. You want to keep this case?
Oh, yeah.
Okay.
Yeah, I mean, he's not, hey, I'm not letting him get out of
I didn't see
your site.
I didn't see a driver's license in the discovery, but maybe it is. I don't know. I didn't see it.
I'm seeing name, phone number, email, address, last 4 digits of the credit card.
You heard what he's saying. What do you have to show me to refute what he's saying, that he had nothing to do with this and it was somebody else using his ID? But y'all indicted him. Y'all had an idea of, and the other person was not indicted, correct?
Not in our county.
Yeah. Okay. What he's saying is y'all have indicted an innocent man. But that's been said before.
Here,
You find it?
what's the picture of it on the far, the new, here it is. This is his ID. It's in the discovery.
Okay.
So PDF, the supplemental was defendant's TDL.
So his ID was uploaded into the case.
Let's, if you don't mind. Thanks.
Mike, do you have it pulled up?
Yeah.
Judge would like to see it.
But I don't know if I gave it to him. We don't have, I don't know if we have a video of the actual transaction or not.
I'm trying to extract the video.
Mm-hmm. Yeah, that's the man, but. Marion County driver's license number. Made a rental contract. And
The offense report said there was another man sitting out in the truck. I don't know who actually went in and sat out. So I'm trying to find out.
that's. So, I would think that they would probably have used his ID and taken a copy of it to be on the safe side when they're renting something that expensive.
Rent.
Jack Reynolds issues contracts by the name of the individual with confirmed verified state issued identifications. Well, they would have looked at it and compared and.
The best hoping with the feds. The full exception was if as first saying if you don't have any evidence said it is a clear state exception underneath this. Even full time knows, right? But you can get past things.
You have any written statements from the complainant? Please.
This is from the, this is who was working at the time. There's not anything about his driver's license in that specifically, but it is in the offense report, Your Honor.
It could be inside of it could be a presence, as we mentioned, but you gotta take a look at it, thinking the efforts potentially is on free, right? Because we don't, we don't run down to. She's not there, that's the environment. Then we turn it to the shooting. Also, but the kids also is sit for one of those play things on the squares, paper presence. He has his ideas. in orchid proper issue. So I was at there, I was actually looking at this morning with us, so entirely different. But the kids all the change that. If it's a problem, so it's actually excited. So those are the signs and then. The conference check to prevention. Website.
You get the media on down here, how on the back.
Oh.
Guys, let's look at it this way. We're already outside of 10 days. Let's look at it and see if we can get it in and hey. The presence and impression are saying they don't read moments. So. That is really good.
Yeah, they got, this is the same one they have a copy of. They use those. This was your ID, the state had it. That's the same one. That's you.
I just don't like that.
We're trying to check on the media, Judge, see if there's any videos of the transaction. Give us a minute.
App. So we got.
I didn't mind. She has a copy of his ID already.
Oh,
they have a copy of it.
It was in the box?
Yes, it's
It's the same. It's the same
in the
ID
discovery.
that
And it's
was used, and that's the one that was
the
used.
driver's license.
He was in there. That was him
as well.
not somebody else. That was him.
Are you accepting responsibility?
Yes, I was just letting them know that that's all.
No, you were letting me know you weren't guilty of this crime. It was somebody else's fault. You didn't know what was going on. That's what you. I'm sorry.
You gotta accept responsibility.
Okay.
Did you do it or not, sir? Did you go in there and rent this thing?
Yes, I will.
So why would you have said otherwise to me? Why would you have said it was somebody else? My goodness. First thing to fix any mess is to be honest about it. Don't compound the problem. All you did was throw gas on a fire that he's trying to put out.
Yeah.
The agreement that has been reached here is that you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, ordered to pay restitution in the amount of $29,000. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty? I didn't hear. Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked here as States Exhibit 1. You just sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
That's just signatures, please ask. No.
Is everything true and correct, Will?
Yes.
States Exhibit 1 is tendered into without objection. And here's, among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and the indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination. And this is where you were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. States Exhibit 1 is moved into evidence without objection.
No objection.
It is granted and allowed and admitted. Pre-sentence report is hereby waived.
Yes, sir.
If nothing further to add, I'm going to follow this agreement. I'm going to find Mr. Kelly, you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I am following this agreement. I find you guilty beyond a reasonable doubt of the state jail felony. You were hereby sentenced to confinement in the state jail for 2 years. That term of confinement is suspended. You were placed on regular probation for 5 years. There will be terms and conditions of probation which you must follow. Failure to follow these can result in revocation of your probation, and you can be placed into the state jail up to 2 years. The most important term, the two important terms, don't commit any more crimes. Number one. Number two, pay these people back. You must pay $29,000. How are you going to do that? Do you have a job now? What do you do?
Warehouse ops.
Okay. How much do you make an hour there? I'm sorry?
$15.
That's about $30,000. Do you have a family at home, or is it just you that you take care of?
This means
Okay. How much are you able to pay per month toward this restitution? This $29,000. That's not going to happen overnight. What can you pay per month? Okay.
Gotcha.
Do you know how long that would take? 23 years. Is that how long you want to be on probation? You have to speak up. She can't put a nod or a shaking of the head. No, you have to speak up. We got to communicate here. Is $100 the most you can do?
200.
Can you? No. Don't put more than you can. Don't stick your neck. If you fail to pay in this, you made a mess. You're trying to fix it. Don't make it worse. What's realistic? 200? 200 is realistic. That's still, that's 2,400 a year.
Yeah.
And at 29, that's still 10 years or 12 years.
That's a cool.
It's a start. All right, what else? Anything else from the parties?
Nothing but state, Your Honor.
All right, please see this lady. She's going to go over all the terms and conditions of probation. You will begin probation. Thank you.
Right here. I think. Here.
That's a struggle. John, Lisa Tala or Thola?
Should have dismissed already, Judge.
That is to be dismissed?
Yes, sir.
All right, hold on, I'm looking. There it is. 25 CR 448. There is a motion to dismiss filed on behalf of the state. Any objection?
No. Mine is deceased.
What happened?
Still don't know why. Oh, happened.
Yeah.
She was in her 40s, I believe. Yeah.
Find that young.
Yeah, very young. That's John Frost.
Here.
What was she charged with here? Fraudulent use of possession of identifying information. Okay. That case is dismissed as the defendant is deceased.
You're telling me.
Diane Rubin.
Oh,
Just the allergies are hitting.
mine are too.
Man, sorry, everybody. Stand by.
Let it happen again.
All right, I'm back. Diane Rubin.
She's in back in Israel.
You go get her.
Man, the allergies are, John, did you change cologne? Cause I'm sneezing too. How about you, Dan?
Yes, sir.
Did you change clothes?
Yes, sir.
Somebody did, because I'm sneezing. I'm allergic.
Please repeat it. Okay.
What's the blessing of the allergies?
Yeah.
Generally, people with allergies do not get seriously ill in the flu because allergies are your system attacking the invaders that are going to cause you trouble. And but it's no picnic if you're sneezing all the time and you got hay fever. But I never get the flu or anything.
I didn't know about that.
Yeah, got it from my dad. My dad had that.
Yeah, I
Spring and fall, we get the allergies.
Her has it too. She's takes Zyrtec.
Funny how nature is. It's not one thing, it's another. Okay, so I've got Diane Rubin.
I do.
Right down there.
Hello, how are you? I think, here, I'm going to turn this down a little bit. I think we're going to end all of this today, hopefully. Okay, Ms. Rubin?
Yeah.
So, okay, we'll see what happens, all right? God bless you. Can you turn the down in the back? That is yours. We got I've got this on over here. Down. Thank you. Good. All right. Ms. Rubin has two cases. What are we going to do?
Your Honor, there's a plea on this one. She recently was revoked on her
In both of
probation.
them?
Yeah, both of them are going to be pled. She was recently, a few weeks ago, we had a revocation hearing. Her probation was revoked and you gave her.
You are Kenan Ardwan.
Yes, sir.
And 22-409-11, 23-41-364. Got 23 CR 30, 23 CR 194, and 23 CR 1195. So these are the 22-409-11 is an indictment for the first degree felony of murder, and it also alleges the prior convictions in sequence, so that as we talked about, I think before, it puts you in a habitual felon status for 25 to life if convicted. 23-41364 is assault, family violence, and the same prior convictions are alleged there. So that third degree felony, if convicted, you're looking at 25 years to life imprisonment as a habitual felon. 23-30 is arson, a first degree felony with the prior convictions as alleged. So you are looking at habitual felon status there. In 23 CR 1194, that's third degree felony of assault on a public servant with the same prior convictions. So you were looking in that case at the same 25 to life habitual felon status. 23 CR 1195 is another third degree felony of assault on a public servant with the prior convictions alleged of habitual felon status. And finally, 23 CR 2207. This is different. This is a burglary of a building, a state jail felony. And those three prior convictions in sequence are alleged. So if all of that is true, that state jail felony, if convicted, you would be punished as though it were a second degree felony. So you're looking at no less than 2, no more than 20 years confinement in prison because those are in sequence. All right. You're still adamant about representing yourself, correct?
I am.
Okay. Have you had a chance to review all those documents we sent to you?
Last Thursday, I received some of the, this last Thursday, I received some of the discovery. There's still the
the media files that I have not had access to. So
What are we doing about that?
one's supposed to do it all.
We sent him documents. I sent documents.
We dealt with the documents. This is, I know that.
What media files are we talking about here? Anybody?
Cell phone dumps, interviews, recorded from witnesses, my statement, about police body cam, those things.
We'll have to make some arrangements, judges. I know that Mr. Eckhart had shown, but I don't have a record of what's been shown. We'll probably have to start over.
Start over. Get it done so all the I's are dotted.
Yes, sir.
When can that be done, do you think? Soon?
We'll have to check, see when our investigators are gonna be here, because one of them may have to come down and show him, correct, sure that he sees everything. Because we'll be busy in court.
All right. Can it be
You
done?
do it quickly, I just need to.
Yeah, I mean, we've got some time potentially.
How soon?
We got downtime next week.
Yeah, well, potentially we can do some, vast majority of it next week.
Just be in the mornings because they have to
See what we can do. And I want to review it in 2 weeks to make sure that it's been done. We're not going to be able to try this before the first of the year. That's all locked up. But we're going to set it early so that we can figure out which way this goes. All right.
Yeah.
Yes, sir. What else, sir? Anything you want? Other than that?
Not at this moment. After I talk to my investigator, this coming week,
Yes, sir.
in 2 weeks, I'll let you know.
Okay. All right. Write down and so you remember and we'll deal with it. Okay. Anything else on this? We're in recess on this. Thank you.
Until somebody feels me.
Anything else today? No, we're in recess. Thank you. Have a wonderful Thanksgiving, everybody.
By Mr. Reynolds. Driving conditions are superb and excellent. Mr. Reynolds was supposed to contact the child support agency and have a discussion. Then today may or may not be removed from the calendar, but that was based upon Mr. Reynolds having contact with the child support agency and the child support agency updating the court as to move today's hearing or to take it off the calendar. Ms. Thomas Schmidt, have you had contact with Mr. Reynolds?
We have not. Mr. Reynolds paid an individual paid Mr. Reynolds bond on his behalf through the jail. So we will be receiving that $2,000. It's working its way through the system. But Mr. Reynolds did not contact the child support agency to update employment, update any of the information he was supposed to update upon his release. He has not done that, which is why today's hearing remained on the calendar. I guess my request is for a $3,000 warrant with a condition of release that he also provide in writing all employment information, including an update as to his employment at the casino and at the A&H General Store.
All right.
And I would ask that we schedule the hearing for the next sanctions date. I have no doubt that he will either be picked up or contact us upon learning about the warrant and request that hearing date. So we might as well get it on the calendar now.
I don't agree. Okay. Because if I put it on the calendar, he could do some little hiding until that date and time and come on in to court that day.
That's fair.
Try and avoid the warrant. Court is set for a reason, and it's set on a particular date and time that fits with the court's calendar and the attorneys, as well as the defendant or respondent at sometimes if there are certain things that come up. Mr. Reynolds has a notorious history for failing to appear, failing to come to court, and or failing to come to court on time. He is also significantly late when he does appear. The court is going to issue a warrant, $3,000 cash. Only judge may quash or posting of the cash. If he's able to post the cash, he'll be provided a new date and time upon posting. Another condition on that warrant is not only to pay the $3,000 on the face of the warrant, but also to update the child support agency of all employment information, including the casino and the A&H store, in writing before he is released from custody. Anything further, Ms. Thomas Schmidt?
No, Your Honor, thank you.
All right, then we are adjourned. Well, this was fun. Real fun. All right, can Mr. Chapman and the jail hear me?
Yes.
Okay, now where is the jail? You're muted. Well, maybe they're not here yet. They're just setting up. There we go. Mr. Boone, can you hear me?
Yes, ma'am.
Thank you.
How are you doing today?
Good, how are you?
Doing all right. Doing all right. Thank you for asking.
All right, we will go on the record in the matter 19 CF 13, State of Wisconsin versus Javon Boone. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman, Defense Counsel, by video conferencing. Mr. Boone appears by video in custody in Burnett County Jail. We're set today in this matter for a plea and sentencing. Mr. Boone, do you understand you have the right to be here in person?
Yeah, I basically am, ain't I?
Yeah, no, well, you're by video conferencing, but you have the right to be here in the courtroom in person and have your attorney with you. Do you understand that, right?
Yes, I do.
And you are appearing by video, as is your attorney. And are you asking the court to allow you to enter a plea and be sentenced by video with your attorney by video as well?
Yes, Your Honor.
All right, thank you. If at any time you have any questions or concerns, or you need to speak with your attorney, let me know, and I'll send you both into a confidential breakout session, okay?
Okay.
And so, Mr. Chapman, I did receive a plea questionnaire waiver of rights form. It indicates that you went over this form by telephone with Mr. Boone. Did you thoroughly go over this document with him?
Yes, I did, Judge, every line.
And he is accepting the offer of an amendment to possession of amphetamine, and it would be a joint recommendation for time served and court costs. Is that correct?
That's correct, Your Honor.
Okay. All right, Mr. Boone, you are pleading guilty to a possession of amphetamine charge. Is that correct?
That is correct, Your Honor.
Mr. Schmidt, formal motion to amend.
So made.
Granted. I do have in front of me that plea questionnaire waiver of rights form, Mr. Boone. Your attorney has informed the court that he thoroughly went over that document with you. Do you recall him going over that document?
Yes, Your Honor.
And did he go over it thoroughly with you?
Yes.
And he went over it with you by the telephone, but are you stating on the record that if you had the ability to sign it, you would sign that document?
Yes, Your Honor.
Did he go over your constitutional rights with you?
Yes, Your Honor.
And do you thoroughly understand those rights?
Yes, ma'am.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that here the state would have to prove on or around January 7th, 2019, you possessed a substance, the substance was a controlled substance in an amphetamine classification, and that you knew or believed that substance was a controlled substance in an amphetamine classification? Do you understand what the state would have to prove?
Yes, Your Honor.
You understand the maximum possible penalty could be a fine of up to $5,000 or imprisonment of up to 1 year of incarceration or both?
Yes, Your Honor.
Do you also understand that there is a joint recommendation for the court to do a time served sentence? Do you understand? I'm not bound to follow that recommendation.
Yeah, I understand that.
You understand that? Okay. So
I do.
if I thought the facts of the case warranted it and I thought it was egregious, I could sentence you to the maximum possible penalty or any other sentence that I think is appropriate. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Now, did you go over the criminal complaint with your attorney? The facts that are alleged there and what happened that day? Mr. Chapman, did you go over the facts alleged in that criminal complaint with Mr. Boone?
Yes, I did, Judge.
Okay,
Mr. Boone
yes. All right, yes, yes.
We talked about how you were at the casino and they searched the car that you came in.
Okay, yeah.
ID. Okay, yes.
Yeah, I understand.
Okay, and for the most part, are those facts accurate, Mr. Boone?
Yes, Your Honor.
Are you admitting here today that you in fact did possess a substance in an amphetamine classification?
Yes, Your Honor.
And you knew it was something in the amphetamine classification?
Yes, Your Honor.
All right. So, Mr. Boone, has anyone made any threats or any promises to you for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently and voluntarily, knowing what you're doing?
Yes, Your Honor.
Are you satisfied with your attorney's services?
Yes, Your Honor.
Did he discuss with you the case and you discuss with him the case and from your standpoint?
Yes, Your Honor.
And so you're satisfied with his services?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Go ahead.
Well, I'm not aware of what the court costs are.
Do you have the ability to pay court costs at all upfront?
I'm in treatment. I get general assistance and stuff. So like I'm going back into treatment. So I don't really have a way. I mean, unless I get a job, I don't really have a way to pay, but I can find a way or something that, you know.
Okay, that's all good to know. But other than that, any other question?
No, ma'am.
As to amended count 1, possession of amphetamine, how do you wish to plead?
Yep.
The court will find your plea of guilty is done knowingly, intelligently, and voluntarily. I find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of possession of amphetamine. The other count will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt?
The reason why we're doing this today is because this is a 2019 simple possession case. When I reviewed his record, I saw since 2019, he's already done probation and treatment in another state. So as it relates to the substance abuse issue he had in 2019, he's already made efforts to deal with that. Based on his statements, it looks like he's still dealing with that in another state. He's also, by my count, and Attorney Chapman, correct me if he disagrees, I think he's got 38 days jail credit, which is quite a lot. He's also forfeited way more than costs and fines across the course of this case. Thank you.
He has. Thank you. Mr. Chapman.
If it matters, I think he's got even more credit than that. Just on this most recent arrest, he was arrested September 10th. And arrested in Minnesota and sent from county to county in Minnesota but all of that was while also on a Wisconsin detainer for this warrant. I believe all of that time would count because he hasn't been serving another sentence up until now. And he just from that time, he's been held for 73 days by my count. But like I said, I don't think it really matters. This deal was negotiated with prior counsel. Mr. Boone is admitting that, yes, he knew the meth was in his car. There was another girl with him who was using a fake ID at the casino. And like the state indicated, he's not a resident of this state. He's still dealing with other charges and he's still on probation in Minnesota. So I don't think we need additional supervision in Wisconsin, Judge.
All right, thank you. Mr. Schmidt, would you stipulate as to the 73 days held in custody?
If it's 73 just this stint, then it'd be 95 total.
Oh, yes. I was just counting from the time he was arrested in Minnesota on this warrant.
So he's actually sat 95 days in custody.
He had 22 days credit prior to this recent stint. So I just added 22 on to the number Attorney Chapman gave.
Okay, thank you. Mr. Boone, is there anything that you want to say, you want to tell the court?
No, thank you, Your Honor.
Okay, thank you. When you're not in custody, are you at that apartment 101 on Lindale Avenue North?
No, that hasn't been my address since 2019.
Do you have an address where you receive mail at least?
Yes, I do.
Can I get it, please?
It is 328 6th Street, Southeast Minneapolis, apartment 305, zip code 55414.
55414. And do you have a telephone number when you're not in custody?
I've been in custody for a while, so I don't have my number anymore. I didn't get arrested on do I need to have an updated? I can give you like my I can give you my son's mom's or
That would be great.
the number is 612-403-9813.
Excellent. If we need to, can we send that phone text messages?
Yes.
Okay, thank you. All right, I think that the agreement is appropriate. You've sat a lot of days in custody on this case because it's been since 2019 and it's been warrant and then you abscond, or warrant and you abscond, or you've been in custody somewhere else or in treatment or something, and you haven't made your court appearance here, but then you've been in custody in Minnesota waiting to come back here. I think that it is appropriate that because you've sat so many days, I'm going to order 120 days of jail with 95 days of jail credit. That means it's a time served, okay? So I'm going to give you the credit that you deserve for the time that you've sat. So 120 days jail sentence, 95 days of jail credit, again, a time served. I'm going to give you a break on the fines and fees. I should be assessing $443, but I'm going to waive $243. I'm only going to order $200 DNA surcharge, and that is a mandatory assessment that I cannot waive. I am going to say that you need to start making payments as of January this next year. And it'll be payments in the amount of $25 until paid off in full. You need to make your payment, or you need to contact the court and let me know why you can't make that payment if you're having a significant or substantial financial hardship. You need to contact the court, okay? Otherwise, a warrant will be issued. You could sit up to 6 months in jail.
Your Honor?
Yes.
Can I say something, please?
You sure can.
So I'm going to be in inpatient treatment until February. So is there any way we can make it where I start paying after I get out of treatment? I mean,
when are you being released in February?
I don't know exactly, but it's a 90-day program. So.
All right, I will say first payment in February. That gives you until the last day in February to make $25. So you should be able to figure out $25. Even if you're released on the 20th of February, you can borrow it and pay it or you can write a letter to the court. But again, Mr. Boone, it's very important that you make at least $25 a month payment, or you pay that $200 off in full as quickly as you can, because I will issue a warrant. You see what happens when I issue a warrant. You sit in custody for a while. You could sit up to 6 months in jail for not paying. It's, again, very important that you pay this. Not only could I issue a warrant and you can sit more jail time, but I would issue a civil judgment against you, because you're always going to owe that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail will make sure that we have that. You have the ability to request it be expunged through a written letter to the Department of Justice. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman?
When we're done, can I go into a breakout room with Mr. Boone to discuss his?
Very quickly, you may, but I need that jail for my next hearing.
I will be
So,
quick.
Thank you.
Nothing else.
All right, thank you, Your Honor.
You're welcome. There you go. I opened the room.
I clicked the wrong button, I think. There we go. Found it.
Mr. Boone, there you go.
That reminds me, if you have any
Mr. Felisky has filed. Kevin Schmidt. Is Vicky coming down?
No.
Okay. We will go on the record in the matter 25 CF 158, State of Wisconsin versus Luke Beechler. The state appears through District Attorney Kevin Schmidt in person. Mr. Beechler appears by video conferencing in custody in Burnett County Jail. We do have his counsel, Joel Felisky, in person. We're set here today on a motion hearing, a four corners motion. Mr. Felisky has filed his motion. I don't know if he filed yesterday or this morning, but I just got it this morning and I reviewed it today or this morning prior to this hearing. And I'll allow you to argue off of it, but I mean, I did thoroughly read it, so.
Of course, Your Honor, and I don't see the need to repeat myself endlessly on it. I think it's fairly straightforward here. Under Wisconsin law, I'm sorry, early morning, whatever. I'll begin. I appreciate it, Your Honor. Sorry, I'll begin again. My main point here is looking on a case, State versus Godesi, 112 Wisconsin 2D 213. In that case, there was a similar challenge to the sufficiency of the complaint based on the facts that were alleged in that complaint relating to intoxication. The court found against Mr. Godesi on the basis that the complaint did reference numerous indica of intoxication, the odor of alcohol in the breath, slurred speech, poor balance, the inability to perform preliminary breath tests, so on and so forth. In this case, Your Honor, the only indication in the complaint itself of any amount of intoxication is Deputy Anton's observation that Mr. Beechler had the odor of alcohol on his person, but there were no standardized field sobriety tests performed. There was no preliminary breath test performed. There was a blood alcohol sample that was taken from Mr. Beechler with his consent at Burnett Medical Hospital, but those results, and assuming they're probably still pending, are not included as part of this complaint. Your Honor, I think the state would likely rely on the statements made by Mr. Beechler to law enforcement, but in reference to those, my concern would be that they're speculative. Mr. Beechler doesn't indicate that he really only indicates that he felt that he couldn't have passed a preliminary breath test at that time. I think in consideration of the law here, requirements for a four corners, a motion to be, or complaint to be sufficient within the four corners requires some indication here when it concerns operating a vehicle while intoxicated, that the operator actually is intoxicated. And there's just not facts here that are referenced in the complaint that would indicate that, other than, again, the admission, which is speculative by Mr. Beachler. And again, somewhat speculatively here, but the theoretical results for the blood alcohol content in his blood, which are again not included in this complaint. I think the complaint here, because of those lack of facts, is insufficient. It doesn't state why Mr. Beachler in particular is being charged with the crime of operating while intoxicated, and I'd ask the court to dismiss this complaint. Thank you.
Isn't one of the distinctions between the facts alleged here in State versus Gaudesi, and that's Gaudesi, that case in the State versus Gaudesi, there wasn't a statement made by the defendant that he believed he was intoxicated, correct?
That is correct, Your Honor. But again, I think the issue here is that this is, again, speculative. Looking at the complaint, the specific language there, it's actually in bold. Mr. Beachler states, quote, he would not pass, and then stated he would be above that. So again, these are very broad statements, Your Honor. They're vague here. He's not indicating really any amount of intoxication, any level. He's just making the presumption, frankly, to law enforcement that he would not be below the legal limit.
Okay, Mr. Schmidt.
The test of a complaint is of minimal adequacy in setting forth the essential facts, establishing probable cause through a common sense and not hyper-technical evaluation. State v. Maxwell, 2000, WI App 112. The defendant argues that the complaint does not allege that there is sufficient facts to probable cause that he was intoxicated when he operated a motor vehicle. More specifically, that element of the offense is whether he lacks the clear judgment and steady hand necessary to operate a motor vehicle, where the pattern jury instruction goes on to say that whatever that is, that standard, if you're less than it by any, then you're below it. The complaint alleges that at 1 a.m, Luke Beachler left a bar, struck a human being with a motor vehicle, said he didn't see how he struck the being, just said car in front of him swerved and suddenly he hit something. He had an odor of intoxicants about him. He refused to do a field sobriety test. He refused to do a PBT. He said the reason why he's refusing to do those is he knew he'd be over the limit. A complaint alleges that he knew what the limit was. There was a discussion about that. Using common sense, it is not speculative when a person says, I think I'm going to be over the limit, because we wouldn't think, hey, he did a PBT on his own beforehand. We think the reason he said that is because he has firsthand knowledge of how he feels, which is why he said that. We've had numerous cases since 1983 that talk about just refusing fields, just refusing the PBT is itself evidence of consciousness of guilt. Here we actually have the defendant articulating, yes, that is the exact reason I am refusing. I have consciousness of guilt. I think it's going to be bad evidence for me. And the reason why is because he knows how he feels. It is not speculative if I said, hey, I have a dry and scratchy throat. I think I might be getting sick, for me to say that because I'm basing it on my subjective experience, even though I haven't gone to a doctor. This is the same, I think, under the common sense standard and not the hyper-technical. This establishes probable cause. Thank you.
Thank you. Mr. Feliski, I do believe that you're vigorously arguing for your client, and that you did a good comparison with the State v. Gaudesi case. However, the main fact that is different between those cases is the fact that Mr. Beachler did make those statements. He did make the statement, and I will read it exactly how it is in the criminal complaint, as you have done. He stated because he would not pass, he stated he would be above that, which is he would be above the legal limit of Wisconsin of 0.08. In the Four Corners motion, Mr. Beachler, so that you can understand that it is probable cause, and the court has to look at all of the things that are stated in the Four Corners. That means all of the words on the documents on those pages to determine whether or not a crime was likely committed, probable cause, and it's likely to have been committed or probably was a crime probably committed. And this isn't the step where the court determines whether or not a felony was probably committed, just a crime was probably committed. Based upon the information contained in the criminal complaint, the court does find that there is probable cause that a crime has been committed. Therefore, the court is denying the motion. Mr. Feliski, I believe you filed another motion to be heard on bond. Are we in victims' rights compliance? We are. So we can argue that here today, Mr. Feliski.
Very good, Your Honor. Again, I won't regurgitate my motion here. I think it's fairly straightforward. Mr. Beachler is not able to satisfy the amount of cash that's been requested by the court for posting bond. I believe it's set at about $15,000 cash right now. He is indigent. He was, prior to his incarceration, employed full-time in the community at Injection Molding Solutions here in Siren. Your Honor, I'm sure as the court is very well aware, the primary factor for setting cash bail is how much it will take to compel the defendant to come back to court. It's my understanding here, based on the facts and circumstances, that Mr. Beachler actually was the reporting party in this incident, despite having been the one, allegedly, struck this individual. He took it upon himself. He took upon that responsibility to immediately contact law enforcement. I sincerely hope that may have had a substantial impact in the medical situation of the victim here. I think that in some ways may have been crucial. I'd also note that Mr. Beachler doesn't have a criminal history here in Wisconsin. I did take the liberty of reviewing his previous place of residence in Arizona, where I believe he got his first OWI. However, that history is incredibly limited, Your Honor. I think it only consists of a few traffic matters. I don't think there's any indication here to suggest that Mr. Beachler, considering the circumstances of this case, would not be compelled to come back to court. However, I do think that the seriousness alleged here would warrant some cash, just not the amount of $15,000. Considering of all this, Your Honor, I would ask for the court to modify this bond down to a $1,500 cash bond with the same non-monetary conditions. Thank you.
All right, thank you. So if I'm hearing you correctly, because I did read your motion to modify bond as well, and quite honestly, I love how attorneys put it in that he does not have a criminal history in Wisconsin, except for the current charges, or his criminal history in Wisconsin is limited, because he could have a significant history elsewhere. That has to come into play. So I do have to consider criminal history outside of Wisconsin as well. But if I'm hearing your argument correctly, it's his criminal history is extremely limited, just simply an OWI in Arizona and perhaps some traffic.
That was my understanding, Your Honor. I'm not familiar with Arizona's case citations and whatnot, but doing a brief review of their public record search for the courts, those were the results that I came across.
Okay, thank you. Mr. Smith.
I agree that bonds should be reduced. I would pause on doing as low as $1,500. I'd ask the court to consider something like $5,000 for a couple of reasons. First, he has only one criminal conviction. It is Arizona. It is something called extreme DUI. I think they just call it that based off the BAC level. The other traffic things are not criminal in Arizona. So he has one prior conviction. It's in 2021. As far as I can tell, he never got a warrant for failed appearance there. He's got no priors in Wisconsin. The main reason why I'm asking the court consider a lower bond here, but still keep some cash is a lot of times I come here, I say, hey, Judge, based upon the seriousness of the offense and the strength of the evidence, certainty of conviction, keep it what it is. In this case, the nature of the injury is extremely serious. Quite frankly, it's great bodily harm. The victim is hard to interact with because they're still in the hospital and still very addled. In this case, the probable cause, you probably noticed when the arrest happened, said, Mr. Beachler said that a vehicle in front of him swerved, he hit something, he stopped, saw it was a person, called help. The court my argument today was consciousness of guilt is why he refused to cooperate with PBD and testing. So he had enough consciousness of guilt to know he was intoxicated, but he still helped this person. If he kept driving and sped off, he could have killed this person. And also we had another person later we interviewed at the bar who said the victim left the bar, went out, and then a white SUV hit him, and then he was hit by Mr. Beechler, and then that first vehicle sped off. Mr. Beechler has been cooperating with law enforcement to help us try to find the other vehicle that also hit the victim. I think that should show some cooperation and collaboration. The main reason why I'm asking to go as low as the defendant's asking is I'm real dubious about the connection to Wisconsin. I understand that he's saying he has a job here, he has family here, that he's living here right now. The OWI in Arizona was just in 2021. In this incident, his driver's license is still an Arizona driver's license. It's still an Arizona registered vehicle. I'm concerned about how much his roots are actually here in Wisconsin versus Arizona. That's my main concern about this case at this time. Thank you.
All right, thank you. Mr. Beechler, when did you move back to Wisconsin?
February.
In February? And am I remembering correctly from another hearing that I'm not sure if I'm remembering correctly, but you were a graduate of Webster High School?
No, I'm currently in the 509 GED program.
Oh, okay. So, but you lived in Wisconsin sometime?
No, not prior.
Oh, so you just moved here from Arizona?
Yeah, I was waiting to get, oh, sorry.
No, I must have been reading, or it must have been something about the victim with Webster or something like that. Okay, all right. So you've been here since February.
Yes.
We're going on a year. You don't have your driver's license changed over. I'm going to guess you don't have your vehicle changed over, which quite honestly, FYI, you have to do it. If you're planning on residing here, it needs to be done within a certain amount of time, really short amount of time, 30 to 60 days or something of that nature. But that's neither here nor there. You are working and that's good. And you have family in the area. I do give you kudos. You are working with the police, or you have been, and you did call immediately. You could have fled as well, like the alleged other vehicle. And that could have had a much bigger impact and effect upon the victim here. So you were doing the right thing, and you continue to show that you want to do the right thing, even understanding the severity of this charge against you, which is a Class H felony that could mean a $10,000 fine, or it could mean 6 years of incarceration, 3 of initial confinement, and 3 years of extended supervision if convicted. Again, those are the maximum possible penalties. I do understand, and before Mr. Schmidt even made his argument, hearing the argument from your attorney and those positive things, the court was in the mindset of modifying and amending bail to be in a lower amount. Even still, the $1,500, I need to assure your appearance, and the fact that you have not done the other things to show that you are going to be a Wisconsin resident. You don't have a home that you've purchased. I don't have any lease that you've signed for a period of year. I don't have your vehicle transferred to Wisconsin. I don't have that your driver's license has been transferred to Wisconsin. So there is still significant risk and cause for concern that you are going to make all court appearances, even with a lack of criminal history other than one OWI. So the court has to be concerned about that. So I am going to modify bond from the $15,000 cash down to the $5,000 as requested by the state, as that is an appropriate amount. You have the ability to continue to ask for a modification down the road if some things can change, or there's more showing of the court that you wouldn't be a flight risk. You wanted to say something, Mr. Beechler?
Yes, the reason why I hadn't had my driver's license changed over is because I was waiting on a copy of my birth certificate from Arizona.
I had scheduled a day off of Thursday, the following Thursday from the day of the accident to go get my license changed over. I have my address changed over with the Department of Motor Vehicles in Arizona, which is why I was not able to get a temporary tags on my registration up here in Wisconsin. So I was just waiting for my license to get my license so I could get registration on my vehicle.
I understand that argument, Mr. Beechler, but so you can understand where I'm seated and
Yes.
what I hear all the time, all the time. I was gonna do it the day after the accident happened. I just got a job, Judge, I'm in custody, and
Yes,
I was to start yesterday. So I hear that all the time, and I'm not saying that you're not a believable or trustworthy person, but seated where I am and the fact that I hear those all the time and the fact that it's been since February, almost a year, yeah, I hear you and I understand that, and I appreciate what you're saying. I still have cause for concern that you're going to appear for court, especially considering other than what's stated in the complaint about where the victim is with the health and medical issues. That's all I have. I don't know if things could get worse. I don't know if things are only going to get better. But I have to go off of what I have. And so the court will amend to $5,000 cash, same conditions. Would you like to get another date? Do we have to have a prelim? Is that what we need?
Yes, Your Honor, I think we still have to go through the initial, but I think we
Okay.
can do that.
Oh, that's right, an initial appearance. So did you go over the criminal complaint with Mr. Beechler?
Yes, Your Honor, I believe he understands the charge here and the maximum penalties. We'll waive formal reading, and we'll also waive time limits for setting the prelim.
Okay, let's get the matter set for prelim. I could do 11:45 on December 8th.
That will work.
$11:45, December 8th. And Mr. Schmidt, so I am aware for scheduling in the future, is this going to be your case or Mr. Vilas?
It'll be mine, but it's fine that was scheduled on his week because he's in custody.
Okay, all right, thank you. We will see you then. I know you waived time limits. I just wanted to make sure this is a serious case. He's asked for a bond modification and I want to be able to have a quicker turnaround.
Certainly, Your Honor.
That's why I scheduled it when I did. All right, anything further?
Not for me.
Then we are adjourned. Thank you. It looks like Mr. Schmidt needs to talk to you and then Mr. Matrius. State of Wisconsin, County of Burnett versus Peter Mulroy. This date appears through District Attorney Kevin Schmidt in person. Mr. Mulroy appears in person with counsel, Mr. Joel Feliski. We're set for this plea and sentencing. The parties have reached an agreement. We were just here on the 19th. But for the record, Mr. Feliski, can you recite the agreement again?
Absolutely, Your Honor. The parties have reached an agreement here for Mr. Mulroy to plead to count 1 in the complaint at 25 CF 116. The state has agreed to amend that down to, I have here, a failure to stop for law enforcement as a misdemeanor, the statute being 346.042T. There's a joint recommendation here. Apologize, I got a little ahead of myself. The traffic matters along with 25 CT 43 will be dismissed and read in, and there's a joint recommendation here between the parties for a fine inclusive of costs, $1,000. I have a completed plea questionnaire with me. May I approach?
You may. Thank you, Mr. Feliski, and I appreciate, but I know the clerks appreciate it so much more when you recite the statute on the record. So thank you. All right, so I have in front of me the plea questionnaire and waiver of rights form. I do understand the facts alleged in this case, along with there was a co-defendant involved. Mr. Schmidt, formal motion to amend to the misdemeanor version.
So made.
Granted. Mr. Mulroy, I have in front of me this plea questionnaire waiver of rights form. Do you recognize the document?
I do.
Did your attorney thoroughly go over the document with you?
Yes, he has.
Did he read it to you essentially word for word?
Yes.
And you understand everything completely?
Yep.
Did he thoroughly go over your constitutional rights?
Yeah.
And do you understand them completely?
Yep.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yep.
Is that your signature on the second page?
Yep. This is.
Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yep.
Do you understand here? The state would have to prove on or around August 8, 2025, you operated a motor vehicle on a highway, you received a signal to stop your vehicle from law enforcement, you knowingly resisted the officer by failing to stop the vehicle as promptly as safety would permit. Do you understand what the state would need to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you also understand that there is an agreement here where there's a recommendation for the court to accept a costs only sentence? Do you understand I'm not bound to follow that?
Yes.
I could sentence you all the way up to that maximum penalty if I thought it was warranted?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? That's that document where it basically says what happened that day and why you were charged with crimes?
Yes, I
For
have.
the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did fail to stop your vehicle as promptly as safety would permit?
Yes.
And you knew that an officer was asking you to pull over?
Yes.
Mr. Felisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty?
No.
You're doing so freely, intelligently, and voluntarily?
Yes.
You fully understand what you're doing today?
Yep.
Has your attorney represented you competently?
Yes.
He's answered all of your questions?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to the amended count one, a misdemeanor version of failing to stop your vehicle, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. All of the traffic matters and other cases will be dismissed and read in for purposes of sentencing. Again, congratulations on getting your license.
Thank you.
That really is truly awesome.
Thanks.
A judgment of conviction will be entered today. Argument, Mr. Schmidt.
Yeah, Mr. Mulroy, I believe this is his first criminal conviction. In this case, there was truly no reason for him to flee from the police. It looked like Dakota fled because he had a warrant, and then he just did because Dakota did. So there's really no criminogenic needs. It was kind of an impulsive bad decision in the moment. To that end, I thought doing the $1,000 fine inclusive of costs would be appropriate in this case, aggregating all those traffic tickets into one fine. I didn't think probation would make no sense, which is the first thing we have to consider because there's no criminogenic needs. And given the lack of history and the nature of this, again, just a bad decision for no reason. I didn't think jail would be necessary either. Thank you.
Thank you. Mr. Felisky.
Thank you, Your Honor. I do first want to address the issue of any custody credit. I see that based on CCAP here and the complaint, Mr. Mulroy was brought into custody on August 8th of this year. It seems that he posted bond and was released on September 5th. By my math, that equals 29 days of credit. Your Honor, I do agree with the state here. I think this is an appropriate resolution. Mr. Mulroy has been very clear with me that he agrees that that was a poor decision on his part, and he certainly does not intend to repeat it in the future, nor to, frankly, make any other decisions that would bring him back before this court or any other. I think that the substantive amount of this fine, $1,000, is no small amount of cash, especially in these times, Your Honor. Is a sufficient deterrent towards any further behavior. I agree with the state that I don't think there's a criminogenic need that needs to be met here. Overall, I think that this is an appropriate agreement. I'd ask the court to follow it. Thank you.
All right, thank you. Mr. Mulroy, any statement you want to make?
No.
And I believe you've prepaid, haven't you?
I believe so, yes.
Excellent, good. Mr. Mulroy, as Mr. Schmidt said, you had no reason to run or to do anything. And I don't know why, and I'm sure it's the adrenaline that's pumping and
Yeah.
seeing law enforcement and just going,
Yeah.
but now you know you cannot, if you've done nothing wrong, don't worry about it. If you get stopped, then they'll just let you go.
Yep.
And I mean, really, that was it here. That was it.
Yeah.
So you have your driver's license now, which I am so thankful for. So thank you for getting that, because then now you're going to not have to worry and not, because that could have been your, I don't know if you had it, you didn't have it by then, did you?
When I got
Pulled over?
I had it at the time, and then afterwards it got taken away for a month or whatever. So
Don't do this again.
no, I don't plan on it.
Don't do it again. You're a good young man.
Yeah.
And you're trying to, you know, live a good, stable life.
Yeah.
So keep that up. $1,000, that'll hit hard.
Yeah.
You've already figured out how to come up with it, especially I think you said you're on disability.
Yep.
And so that hits you even harder.
It does.
I know you can work on disability. I don't know the limitations or whatnot.
Yeah.
I'm hoping that you're going to be out there doing something so you can keep yourself active.
Yeah.
Because that'll keep you out of trouble.
Mm-hmm.
So what the court is going to do is, I am going to sentence you to 30 days in jail, 29 days of jail credit. It's a time served. You've sat the time.
All
It should
right.
at least be on there to show that you sat the time,
Yeah.
because that was a punishment.
All right.
And had I known all of these other factors and all of these other things, you know, that's a long time to sit when you left when you shouldn't have left,
Mm-hmm.
and you had nothing to leave for. So 30 days of jail, 29 days of jail credit. So that's a time served with good time, et cetera. $1,000 fine. You've already prepaid it. That's good to go. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. When you're done here, you're going to need to go to the jail, to their booking, and you're going to need to provide your DNA. If they need it, they'll say, yep, and they'll swab you. If they don't, they'll say you're good to go and free to leave. You have the ability to request that your DNA be expunged from the system through a written letter to the Department of Justice, not to this court, but to the Wisconsin Department of Justice. You can Google it. It's easy, or Mr. Felisky can help you if that's what you want to do, okay?
All right.
I think that covers everything, Mr. Schmidt.
Nothing for me.
Mr. Felisky.
Nothing further. Thank you.
All right. Good luck to you, Mr. Mulroy.
Thank you.
The state appears through District Attorney Kevin Schmidt in person. Ms. Gangelhoff appears in person with counsel Joel Felisky. We're here today in this matter because Mr. Felisky has filed a motion to withdraw. He has indicated that there has been a breakdown in your communication, Ms. Gangelhoff. In a hearing like this, the court needs to know certain things as to the relationship to determine whether or not to permit a withdrawal. I understand, and so you can understand it. Mr. Felisky is in a bit of a quandary because his job is to keep your conversations and communications confidential. So he will not say anything that would release or break that confidentiality, okay? Unless you give him the ability to do so. I want to hear from you to see what your perspective is and why you think there's been an irretrievable breakdown of communication.
Because he's been lying to me this entire
I don't want
time.
to, I wouldn't say that.
I would. I mean, he's completely lied to me this entire time, telling me something that isn't true, telling me that this driver's license business was not going to be a problem. It's okay. Just give up your preliminary hearing. It'll be all right. And I don't know what to do with that.
What I'm hearing is that you may have a different understanding of the facts and the law and how it affects, and that's fine. And I'm hearing that you believe he may have told you mistruth or untruths or mistruths.
Yeah, or led me to believe, something just simply wasn't true. Either he didn't have the information to make the claim in the first place. Like it was a problem. It is an issue. And 7 months later, you're going to.
Your driver's license?
Yes, which I told him day one.
That you can't get it?
Yes. And it's okay. It's okay.
Well, then if
it's not
if
okay.
You can't get your driver's license, then I'm going to tell you, you were cited with operating without a valid. I don't know your criminal history. I don't know if you've been cited with that before, but I am going to strongly encourage you. I'm not going to order you.
Yeah.
But I'm going to strongly encourage you not to drive without a valid driver's license. You could get into a lot of trouble down the road. Part of the offer was, if I'm recalling correctly, get an AODA assessment and do that follow through, and then get your license if you reinstate your license. Well, with operating without a license, you've never had a license.
Well, it's expired only in Wisconsin.
Okay.
That's it. But I must have waited too long. So now
you have to do everything.
Well, they check the other surrounding states, they'll check the Minnesota. My Minnesota is not good, so they won't probably, but I haven't even ever asked. I've been trying to deal with Minnesota this whole time. I've never gone into the Wisconsin DMV and just tried to renew my license,
I'm going to tell you, you won't be able to renew your license in Wisconsin until you take care of Minnesota.
And that's where I'm at. And I can do that, but not for a while. And it's going to take a lot of money. So.
Well, and here's the thing, that whatever, you get to accept an offer you wish to accept, or we can set the matter for trial, but you're facing a felony and 2 misdemeanors.
Exactly.
So I'm not going to get into the ins and the outs about any offers or any negotiations or anything of that nature, but I am going to tell you that there is an offer out here for the assessment. Get that complete, do the follow through, and then reinstate your license. And then it would be to plead to a THC for costs, I believe.
Exactly. That's what I been trying to do, because he keeps reassuring me that the license will not be a problem. But now it is.
I'm not going to ask you what he's saying with that, because there's multiple ways that can be inferred. And whether or not you get your license or you don't get your license, Mr. Schmidt, is there an offer without her getting her license? Because it sounds like she's having a difficult time getting her license.
There is an offer.
There's been a few. It's just, I've always presumed she could get her license.
Well, and what I'm hearing today is it's difficult for her. She has to go through a couple states. So do you recall the offer without getting your license?
Not exactly.
I never made one.
Okay.
No, Your Honor, I do want to correct. There was an alternative presented by Mr. Schmidt, which I did relay to Ms. Gangelhoff regarding this case. I'm going to pull up that email right now. It's an offer to plead to 1 count of operating after revocation, 1 count of misdemeanor amphetamine for costs on each.
Okay, and don't get into the ins and the outs of that. That's just the offer that's presented by the state. And again, that's your call to make if you wish to accept or reject any offer. And it's only for your attorney to relay to you what the offers are and pros and cons of each. But I'm hearing that there has been a massive breakdown, and I would say irretrievable breakdown in the relationship, in the communication. I'm not even going to go through all of the other factors, because I looked, these charges arose out of April 2025. Mr. Flisky has been your first public defender. So you can understand, though, that if the court is going to allow him to withdraw, but you'll be appointed a new public defender. You don't have, if this happens again, I will go through all the factors, and quite honestly, the fact that I'm hearing that you're saying that he's lied to you or all of those other things, that you have opened up the can of worms where he can spill his guts about all of the conversations and exactly what he's said to you and what you've interpreted of what he said to you without breaking confidentiality. but I'm not going to make him do that if he doesn't want to, because I'm just going to allow him to withdraw. So if you come back and you have another public defender and the same issues are occurring and you're saying that they're lying to you, whatever, that can of worms will be opened. They will be able to respond to those accusations, okay?
Okay.
Because I'm going to let you know on the record, Mr. Feliski, he's been practicing in front of the court. I don't know if it's been a full year now. He's been doing a fabulous job. And so it's hard for the court to believe that he would be outright lying to you or telling you mistruths. Okay?
Okay.
It just seems like there could be a different interpretation from what you're hearing versus what he's saying versus what the law is versus what an offer is from the state. And as I've heard now, there's two offers. There's one offer that's a really smashing good offer perhaps, and there's another offer that is based upon if you can't get your driver's license, and that's for the state to do. Or the state can withdraw all offers and say, we're going to court or we're going to trial and we're going to face these all right now and set them. So you have plenty of options to consider. And Mr. Feliski will be notifying the public defender's office that you are now in need of another attorney. Another attorney will be appointed and you will go through the same things that Mr. Feliski has went through with you, the facts of the case, the offers that are made, and you will tell this other attorney what you found out about your license. And what it's sounding like here today is it's, I don't want to say impossible for you to get your license, just difficult.
Mm-hmm.
And so that can come into play with an offer, but the court, I'm sorry, I'm not going to wait 6 months or a year to wait until you get your license before these cases are set for trial.
Yep, I understand.
Okay, so the court is going to sign the motion to withdraw. And you'll be able to get another public defender. But again, I do have to let you know that when you say accusations like that, that does open up the ability for the attorney to be able to respond to those accusations. And you are indicating that, I mean, it's a break of confidentiality on your part by saying, because he's going to have to respond.
Yeah.
I guess I never asked you, would you like to respond? I wasn't going to put you in the hot seat.
Your Honor, out of respect for the confidentiality of our conversations, I'm not going to respond.
Okay, completely understood. All right, so let's get another date and time.
I just want to say, I want to get this, settled as quickly as possible, as much as anybody. And, this whole business was news to me too.
I'm glad to hear that you want to resolve it. I'm glad to hear that you're doing all of the things that you need to make sure that it can happen.
Yeah.
I can schedule you for 3 o'clock on January 14, 3 o'clock, January 14, okay? You can come get your notice and you're free to leave.
Thank you.